I've seen him. There you go. I haven't seen him. Yeah.
Mr. Heinz, you're here on Esker Properties?
Yes, Your Honor. Esker Properties
Right.
versus Patsy Price.
All right, we're awaiting Ms. Price. Is that correct?
I would believe so, Your Honor. It doesn't look like she's anywhere in the system yet. She's there.
All
in the
right.
court.
No, I don't think so. How about and Mr. Cox, you're here on Capitol Commons and Roderick Taylor?
Yes, Your Honor.
And is Roderick, I don't see Roderick Taylor here yet either, so we're waiting on him. Is that correct?
That's correct. And it's his motion, Your Honor.
Okay, thanks.
Thank you.
How about Caplate Pierre? Or Shirley Holton? How are you, Mr. Brodowitz?
I'm good, Your Honor. Yourself?
Are you, do you have anything at 8:30 that's ready?
Let me just go call the hallway really quick.
All right. Well, we get to 8:45, so we're early, but if anybody's here. So. All right, so we're on the record in docket 22-03248, 22-03250, and 23-01340. That's people of the state of Michigan versus Mark Mitchell. Will the parties please introduce themselves for the record?
Jeff Braddock's on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Mitchell.
And sir, you are Mark Mitchell?
Yes, sir, I am.
All right, you
Yes,
can
sir, Your
hear me
Honor.
all right, Mr. Mitchell?
Yes, sir, Your Honor.
All right, this is the time set for, it looks like a pretrial on 3 matters. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. As I'm sure the court remembers and is aware, Mr. Mitchell has several cases spread throughout the county, and there was an attempt at a global resolution. That original global resolution did not end in the result that was originally planned. However, the prosecutor's office has made a new offer on these cases, and that would be, since I believe Mr. Mitchell has already waived his exam and been bound over on the armed robbery felony count out of 55th, that all of the restitution in the misdemeanor cases would be compiled and added to that file. And then upon successful plea in that file and the agreement to pay restitution, the people would dismiss these 3 matters.
So this is a global resolution with the bind over, but the case has been bound over, and it's on restitution. Is that your understanding, Ms. Robinson?
Yes, Your Honor, that date's set for, I believe, June 28th up in circuit court. So hopefully we can get that done by then. These will be dismissed.
All right, so global restitution, this is restitution on file 22032448, 23-01340 restitution, and 22-03250. So are you anticipating that we adjourn this past the plea date, or is this, how's that work, Mr. How are you?
That would be what I would ask, Your Honor, is to set it for, I believe, July 4th. Well, probably, I don't know if we'd be in on that date, but the next available pretrial date after that, to
Get past the
Yes.
plea date.
Yeah, I mean, I don't know what the prosecution's office is going to do as far as if they're going to dismiss it at plea or sentence, but I mean, that's the
Right.
plan. So
Yeah.
hopefully
Right.
they'll just dismiss it
And-
at plea, so we don't have to go through the
Yes.
rigmarole. But
All right, so what's the plea date on this in circuit court?
That I looked yesterday, I didn't see.
the final pretrial date is on June 28th at 9 a.m. And that's when all cases are set for. Hopefully, we can just do a plea on that same day.
Yes.
Sometime past June 28th?
Yes, Your Honor.
Okay, so that's why you're asking for past July 6th or,
Yeah, or whatever, I'm not
All
sure.
right,
That first Tuesday afterwards is July 4th, so I'm not sure.
all right, and then you'll have a number for the restitution concerning these files at circuit court.
Yes, Your Honor.
Okay.
It'll all be in circuit court.
So we need a plea date or we'll set it for a final pretrial date plea on.
The next available date after the time is July 18th at 9, or at 8:30.
Ms. Robinson?
The July 4th, and you're on judicial.
1 second, Mr. Mitchell.
4th,
And then you're on,
and then I'm gonna leave next week.
unless you want to set it on a Thursday.
No, let's make sure it's done, so. But we can set it on a Thursday just to, but I don't know who's here on a Thursday. I know Mr. Brodowitz, Ms. Robinson could be anywhere, so.
If I'm not here, I'll find somebody to cover it. Like, I mean, honestly, it's probably not even going to be heard on the calendar anymore.
Right.
It's gonna get
No, yes,
dismissed, so it
the
doesn't
plan, yeah, the
matter.
plan would be that once the plea is.
Are you looking at July 8th?
Okay, July 6th.
Let's do July 6th.
What time?
July 6th.
8:30?
8:30. 6 at 8:30. 6. All right, so Mr. Mitchell, you understand, and you can talk to Ms. Robinson. We've adjourned this July 6th will be after your circuit court date in regards to resolving these 3 files. Do you understand that, sir?
I didn't get a chance to speak to anyone last week when I went to circuit court, so basically
All
what's going on.
right, it's my understanding is that they're wrapping these files up with whatever's going on in circuit court.
Okay, may I speak to my lawyer for a moment?
Yeah, as soon as this hearing's over and Ms. Robinson has some time, she'll talk to you.
I honestly can't answer any questions about your circuit court case, Mr. Mitchell, because I'm not the attorney on that. So you're gonna,
This case.
yeah, on
This
these
case.
cases, it's all getting wrapped up with your circuit court case.
Okay,
Okay.
I was under the understanding between you and I that we were gonna take care of these today. These are the last few cases I have left, except for my, reading the stuff that's
Correct.
out.
These cases are gonna be, yeah, you're right. Your understanding is right. They're just gonna be resolved with your circuit court case. We're just making sure that that circuit court case is resolved.
Okay. I haven't spoken to a lawyer, Your Honor, in weeks about my circuit court
We spoke
case.
on
In
Friday,
fact-
Mr. Mitchell. No, we spoke
No.
on Friday, so we're not gonna play that game.
No, excuse me, ma'am. I'm talking about specifically you, Ms. Robinson. I'm talking about my lawyer, Mr. Feigelson. I haven't spoken to my lawyer in my felony case.
Ms. Robinson is your lawyer. Oh, you're talking about your circuit court, Mr. Feigelson.
I haven't spoken to Mr. Feigelson in a
All right.
month, sir.
All
And
right.
there's 2 preliminary examinations where he's missed. So I don't know.
No, these are all misdemeanors, so you don't get any preliminary examination on these files.
I understand.
I'll put a note in the file for Mr. Feigelson to come talk to you, okay, Mr. Mitchell?
I've been having that problem, however, Ms. Robinson, for a month now.
All right,
It's been-
all right.
I don't know what's going on with the case that could possibly put me away for life.
All right.
Not these misdemeanors.
Just talk to Mr. Feigelson. He'll be there to talk to you. We've set your misdemeanor cases past your circuit court cases to be resolved when your circuit court case is resolved. None of these are felony files. They're all misdemeanor files, and they're waiting a resolution in circuit court. So Mr. Feigelson will be out to see you, sir, okay?
Is there any way that I can have them separated from the global resolution?
Well, you'll have to
And
talk
have
to
them taken care
Mr.
of
I don't know
today.
if you want to do, A, I don't know if you want to do that. B, you should talk to Mr. Feigelson about that.
And I would love to if he would possibly come see me.
Mr. Mitchell, I'm gonna put a note in the file, okay? So he will be out to see you shortly. But there's not really anything else we can do for you today in district court, but I will put a note in for the file.
All right.
I just
So
need to make
Mr.
sure
Feigelson will be out to
it's on
see
record
you.
also that he hasn't been to see me.
All right. So that's all for the record in these 3 files, 22-03248, 22-03250, and 23-01340. Mr. Mitchell, Mr. Feigelson will be out to see you. Thank you for your appearance today. Now we can call Mr. Heinz. I think we can call your case now.
That's fine, Your Honor. Thank you.
Yeah, let me find it and we can call it. Here we go. Oh, no. 22. 019. 17. Here we go. All right, so we're on the record in docket 17-02377, Esker Properties LLC versus Patsy Price. And I have this set for a discovery motion that was initially filed, and then we wanted to make sure that service was in place. So I have service. Well, your appearance for the record, Mr. Heinz.
Thank you, Your Honor. John Hintz appearing for the plaintiff Esker Properties. And as the
All
court
right.
has correctly stated, this was the time and date set for a civil creditor's examination. And Miss Patsy Price was personally served on May 2nd, 2023 at a mutual meeting place, Your Honor.
Correct. The meeting place, and she was personally served. It was scheduled for 8:30. It's now 8:47. I don't see a Patsy Price in the physical courtroom. I don't know who is on Asante's iPhone, but I don't know if that's Patsy Price or not.
That's Mr. Parker.
That's Mr. Parker, okay. And I do not see a Patsy Price in the Zoom courtroom. So it appeared that the defendants once again failed to appear for the discovery hearing. Mr. Hintz, how would you like to proceed?
Thank you, Your Honor. As Ms. Price has not appeared, and this is a relatively older case, I'd respectfully ask the court for permission to prepare and issue a bench warrant so that she might come in and answer our questions. The amount of the judgment, Your Honor, is not very much, but we would still like to talk with her and try to resolve this issue.
So your request is the court will grant you a bench warrant in this case if you follow it up with an order.
I will follow
I
up,
have,
Your Honor.
all right, I have the initial amount was in the realm of, looks like initially, I'm gonna find the paperwork. Looks like looks like originally was in the realm of $9,000.
I think, not to contradict the court, Your Honor, the money judgment I'm looking at shows approximately $403.84 was the original judgment amount. With court costs and interest, we're getting closer to $500.
All right. Right. So I do have that from Judge Alderson, the money judgment being 403. So I will issue a bench warrant in order to follow.
I will do so, Your Honor, and prepare that and submit it.
All right. Anything else for the record on docket 1702377, Mr. Hintz?
No, Your Honor. Thank you very much. I appreciate your patience.
Thank you.
Have a good day.
You too. All right, Mr. Visconti, you're here on Capitol Commons.
Yes, Your Honor. I am.
All right. And this was, so we're on the record in docket 23-00530. That is Capitol Commons 2 versus Roderick Taylor. Will the parties please introduce themselves for the record?
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
All right, and this is the time is set for a motion to set aside the verdict. I do not see a Roderick Taylor in the Zoom courtroom. He is not the individual in the waiting room. Is there anybody by Roderick Taylor in the physical courtroom? Roderick Taylor? It appears that Roderick Taylor has failed to appear. This was a request by Roderick Taylor for motion to set aside judgment, indicating that when the default happened, failed to appear that he was in the hospital. But I don't have anything to indicate that Mr. Taylor is here on his own motion. Mr. Visconti, you of course know that the criteria for to set aside verdict is a meritorious claim, and then some reason why they did not initially appear. So, but the plaintiff is not here on his motion. Did you have any comment, Mr. Visconti?
So, Your Honor, it is a standard, obviously, of good cause and a meritorious defense, and there may be good cause if Mr. Taylor was in the hospital. However, there's no meritorious defense stated in the motion. Also, the motion was not filed timely. It would have had to been filed in the court by May 1st. He did not file it until May 16th. And I have verified with my client that no portion of the judgment has been paid, nor has any rent which accrued since the date of the judgment. So he's only gotten further behind. So again, for his failure to file timely, his failure to state good cause and a meritorious defense, and his failure to appear, I would ask the court to deny his motion.
All right, thank you. I was set for the record. This is scheduled for 8:30. It's now 8:52. It appears the plaintiff has failed to appear once again. The first question I ask is for some medical documentation concerning a hospital stay. I don't have any of that was attached to the motion to set aside. It was untimely. It was not filed timely. So for those reasons, I'll deny the motion is untimely filed. Plaintiff failed to appear. And Mr. Visconti, will you follow that up with an order?
Yes, Your Honor. I'd be happy to submit an order denying his motion.
Okay. All right. Anything else for the record? Docket 23-00530, Mr. Visconti.
Nothing further, Your Honor. Thank you so much and have a good day.
Thank you. You too.
Thank you.
Peter Catholic. Civil cases for. So we don't have any service on this. So on the record in docket 22-01932, that's Pierre Caplet or Caplet Pierre versus Shirley Holton. And I do not see either party present in the Zoom courtroom or the waiting room. Is there a Caplet Pierre in the physical courtroom? Is there a Shirley Holton in the physical courtroom? This was set for a discovery hearing. Ms. Holton was never served in this. This was there's a return to sender on any mail that went out to her so that we don't have personal service. So at this time, the case is dismissed for both parties failed to appear. Called it set for 8:30 and it's now 8:55. That's all for the record on that file 22-01932. How about Miss Enright? Have we had Miss Enright
She's here.
She's here. Did you want to put her on the record?
Sure.
All right. All right, so we're on the record in docket 23-01422. That is people of the state of Michigan versus Samantha Enright. Will the parties please introduce themselves for the record?
Jeff Prados on behalf of the people, Your Honor.
Erin Robinson, Assistant Public Defender for Ms. Enright.
And ma'am, you are Samantha Enright? Okay. This is the time set for a final pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's date and time set for final pretrial. The people have subpoenaed witnesses. I've called the hallway in the courtroom. Those witnesses have failed to appear. The people would be unable to proceed at this time, so I would leave it to the defense.
Ms. Robinson.
You make a motion to dismiss, Your Honor.
All right. With the understanding that this is the time set for final pretrial, witnesses have not appeared, so the witnesses have failed to appear. The court will grant your motion to dismiss without prejudice. And I'll sign a nollie to that effect. Ms. Enright, what that means today is that the court is moving to dismiss without prejudice because the people are unable to proceed without their witnesses. That means that the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, ma'am? All right. Anything else for the record in docket 23-01422, Mr. Brodowitz?
Nothing from the people, Your
Ms.
Honor.
Robinson?
No, Your Honor, thank you.
All right, Ms. Enright, you're all set.
We can go on McKissick too, Your Honor.
All right. So we're on the record in docket 22-02378. That is people of the state of Michigan versus Anthony Ray McKissick. Will the parties please introduce themselves for the record?
Jeff Prados on behalf of the people, Your Honor.
Erin Robinson, Assistant Public Defender for Mr. McKissick.
And sir, you are Anthony McKissick?
Yes, Your Honor, I am.
Thank you. This is the time set for a final pretrial in the matter. Mr. Brodowitz, how we proceed?
Yes, Your Honor, as you stated, today's the date and time set for final pretrial. The people have subpoenaed one witness in this matter. I have called the hallway in the courtroom. That witness has failed to appear, so the people would be unable to proceed at this time.
Ms. Robinson.
Make a motion to dismiss, Your Honor.
Right, with the understanding that this is time set for final pretrial, one of the witnesses the lead witness failed to appear. The motion to dismiss is granted. So, Mr. McKissick, what that means is, for our purposes today, they could refile to dismiss without prejudice. They could refile if they choose to, but for our purposes today, the case is dismissed. All right, sir?
Thank you, Your Honor.
Thank you. Anything else for the record in docket 20-0237A, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. McKissick, you're all set. Ms. Boyce?
Yes, this is.
All right. So we're on the record in docket 23-01326. That is People of the State of Michigan versus Olivia Moyse. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Moyse, who is standing to my right.
And ma'am, you are Olivia Moyse?
Yes, Your Honor.
All right, this is the time set for a final pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's the date and time set for final pretrial. People have subpoenaed witnesses in this matter. However, I've called the hallway in the courtroom and those witnesses have failed to appear, so the people would be unable to proceed at this time.
All right, Ms. Sutter.
Thank you, Your Honor. At this time, given the non-appearance of the subpoenaed witnesses, I would ask the court to dismiss the case.
All right. Ms. Boyce, you understand that first of all, this final pretrial, plaintiffs have failed to appear. The court is going to grant the motion to dismiss. It's dismissed without prejudice, which means that the people could reissue if they choose to. But for our purpose today, the case is dismissed. All right, ma'am. Anything else for the record? Docket 23-01326, Mr. Brodowitz.
Nothing from the people,
Ms.
Your Honor.
Sutter?
Nothing further.
All
Thank
right,
you.
thank you. You're all set, Ms. Boyce. Mr. Schaefer. Mr. Schaefer, you're here for your 9 o'clock?
I am.
Okay. So we're on the record in docket 23-01381. That's People of the State of Michigan versus Jeffrey Smith. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Smith. I do not believe he is present at this time.
All right, so this was initially scheduled for 8:30. It is now 9:01. And I do not see Mr. Smith in the Zoom courtroom. I don't know if it is that, you know, is he on the numbers, or do we know? I'm afraid to admit everybody. Just
constraints there.
okay. Sir, on the yes, 2945. Can you identify yourself on the cell phone?
Roderick Taylor.
Roderick Taylor.
Roderick Taylor.
That was one of the civil cases.
Mr. Taylor, stand by. You're in the right place, but you're late.
I know they just made me come through.
All right. Well, and then, ma'am, on the iPhone, would you identify yourself? That's Steen.
Yes.
Okay. All right. All right, so with that understanding, Mr. Taylor, we're in a hearing, and then I'll talk to you in just a second, all right?
Reason why I'm
Mr.
not
Taylor,
there because
Mr. Taylor, we're in a hearing,
Yes.
and then I'll talk to you in a second, okay?
okay.
All right. So we're on the record in docket 23-01381. Parties have introduced themselves for the record. Mr. Smith is not in the Zoom courtroom. Is there a Jeffrey Smith in the physical courtroom? With that understanding, this was scheduled for 8:30. It is now 9:03. Mr. Brodowitz, how are we proceeding?
At this time, Your Honor, I would just put onto the record the people did subpoena witnesses. However, the complaining witness in this matter has also failed to appear. So the people would ask that a bench warrant be issued, any bond be forfeited, but ultimately, I guess we'd leave that up to the court's discretion based on the witness's failure to appear as well.
All right, Ms. Sutter?
Thank you, Your Honor. I understand that Mr. Smith is not here. However, the complaining witness was subpoenaed and is also not here, so I would ask the court to consider dismissing this case.
All right. Well, I don't want to reward Mr. Smith for not coming to court. That seems to be a bad idea. So because if Mr. Smith came to court, he'd have the case dismissed. Mr. Smith did not come to court, and so we'll issue a bench warrant and bond forfeiture.
Would the court entertain a 48-hour hold?
I will entertain a 48-hour hold given the circumstances. This is a defeat. It's an assaultive crime, but it's within the court's discretion. And since if Mr. Smith can get in here within 48 hours, I'll entertain the case at that point in time.
Thank you.
So we'll play this. So 48-hour hold on the DV. And anything else for the record, docket 23-01381, Mr. Brodowitz.
Nothing from the people.
Ms. Sutter?
Nothing further.
All right, thank you. All right, Mr. Taylor, your file on your motion has been your motion's been denied because you were late today, and so it was a fail to appear.
The reason why, sir, because I'm at dialysis.
All right. Well, I'm going to need, first of all, I would have needed some medical documentation anyway, but you're 35 minutes late for your hearing. You don't have any medical documentation, and your motion was filed untimely. So if you want any recourse, you're going to have to go back to the civil department. All right, Mr. Taylor?
Okay.
All right. So go back to the civil department if you want any recourse, and they'll reconsider your motion to set aside. But your untimeliness and your untimely file is really what ended up costing you a denial in today's date for fail to appear.
Well, I've been trying to call since 8 o'clock. I couldn't get through to nobody.
All right. Well, you were supposed to be in court at 8:30.
I understand.
All right. Well, there is a recourse for you, sir, but it's going to be with the civil department.
Sir, I'm on oxygen, and I don't have oxygen tank to bring with me.
Well, I can't help you, except I can tell you to contact the civil department, and we're on to other cases.
Well, is anybody else I can talk to to schedule another court date?
I can only talk to you and say to contact the civil department. There is no other court date at this point.
Can I do it over the phone?
You could, but you've got to show up, and there is no other court date at this point. So, Mr. Taylor, did he show up? Okay. So, Mr. Taylor, we're on to other hearings. Thank you for your appearance today. All right. So we're on the record in docket 23-01381. That is People of the State of Michigan versus Jeffrey Smith. Mr. Smith, you can come on up here. This is the time set for pre-trial that we previously called. It was scheduled for 8:30. It's now 9:03. It's now 9:07. It appears that Mr. Smith has appeared. We placed a 48-hour hold on the bench warrant. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor, as stated previously, today's the date and time set for final pretrial. People have subpoenaed witnesses, and the witnesses have failed to appear, so the people would be unable to proceed at this time.
Ms. Sutter, is that your understanding?
It is, Your Honor. At this time, I would request the court dismiss the case.
All right. Mr. Smith, showing up late was a good idea today, all right? Because it kept the bench warrant off, but it appears the case is going to be dismissed. All right, sir? Okay, so witnesses failed to appear for final pretrial. And at this point in time, the motion to dismiss is granted. What that means, Mr. Smith, is that the people could reissue if they choose to, but for our purpose today, the case is dismissed. All right, sir? All right, thank you. Anything else for the record? Docket 23-01381, Mr. Brodowitz.
Nothing from the people, Your Honor.
Ms. Sutter?
Nothing further.
All right, thank you.
I'll be right back, Your Honor.
Would the individual on the cell phone 2945 please identify yourself?
Sarah Steenbeck?
Okay, Ms. Steenbeck, that's you?
Yes, I think so.
All right. Thank you. You're set. So you're set for 9 o'clock. I'll call your case. You're with Ms. Sutter. Is that correct?
Yes.
Do you need the opportunity to speak to her before I call the case?
No, I have not yet.
All right. Thank you. So stand by. You're in the right place.
Oh.
Sir, Miss, on the cell phone 2945, can you identify yourself? Cell phone 2945?
Roderick
Mr.
Taylor.
Mr. Taylor, you need to call the civil department.
I don't have that number.
Okay, the civil department number is 517-483.
Wait a minute. Just, 517.
483. 4426.
Okay, that's enough. I've been calling. I couldn't
All right.
get through.
All right, well, keep trying.
Okay, thank you.
Thank you.
If we have someone who. So, who's-
All right, Mr. Schaefer, we're gonna call your case, and what we're gonna do is, we have the interpreter here, so there's no just because we had it as, are you a Bosnian or Croatian?
Bosnian, I speak Serbo-Croatian. Yeah.
All right, so I'll go ahead, and my understanding is, Mr. Simonovic is there he is right there, all right. All right, so I'm gonna raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, or impartially interpret in the matter now before the court and not divulge confidential communication, so help you God?
I do, Your Honor.
All right. So state your full name for the record.
Mahbuba Fida,
Okay, you're gonna have to spell that, ma'am.
Mahbuba, and last name Fidda.
Okay. So I'm gonna break up. I'll pause and allow you to speak. So
No problem.
we're on the record in docket 23-01023. Will the parties please introduce themselves for the record?
My name is Mahbuba Fida, and I'm translating from Bosnian to English, English to Bosnian.
All right, and go ahead and indicate what I just said.
Кажете, явите свое имя, кажете ko ste vi. Ja sam Mahbuba. Ja ću prevoditi sa bosanske na engleski, engleski na bosanske.
Mr. Schaefer, does that work for your client?
I think so. If there's
All
a
right.
problem, I'll let you know.
All right, thank you.
And my name is Stuart, Stuart, R. Schaefer, Schafer, on behalf of Mr. Simonovic, who's standing behind
All
me.
right.
We're both on Zoom.
All right, and sir, you are IVICA Simonovic?
Vi se Ivica Simonovic. Kažite svoje ime, molim.
Ivica Simonovic.
All right, thank you. Mr. Brodowitz?
Oh, first of all, it's Jeff Brodowitz on behalf of the people.
Go ahead, ma'am.
Ono to na strane naroda da jave svoje slučaje.
And this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Kaže kako vi se će nudite, kako ću, da li idete?
Yes, Your Honor, after conversations with the defense, I believe this is going to be set for a final pretrial.
Kaže, ovo sada na pre-trial, danas ćemo odužiti kad ćemo napraviti pravek suda.
And that's your understanding with, go ahead.
Kad će biti sud, danas će oni će određiti kad će biti sud.
And that's your understanding, Mr. Schaefer?
It is, Your Honor.
All right, thank you. So we'll set this for final pretrial. We'll go ahead and do a corresponding jury trial date with the final pretrial date, with the final pretrial date somewhat dispositive. And our date is, go ahead.
Danas ćemo javiti kad će biti sud. Određena datum, ovo ću vam reći kad će biti određena datum, kad će biti sud.
June 27th.
Your Honor,
Yes.
I may, I spoke with the victim in this matter yesterday, and she has a pre-planned vacation, and will be leaving on the 27th and won't be back until the 18th of July. And so I would ask that either her appearance be excused for that final pretrial or any dates not conflict with that.
So 27 to 18?
Yeah.
Kaže, victim oni su ima planove da ide na odmore od 27. junija do 18. julija. Kaže, neće biti ovo ako sud bude posle toga.
All right, so it's my understanding, Mr. Schaefer, and I'll kind of put it in your ballpark. We can have the final pretrial before the 18th in order to guarantee the victim's appearance here, or we can post date it to after, I'm sorry, before the 27th to guarantee the victim's appearance, or we can post it to after the 18th.
Kaže, mi možemo prije 27. da određemo da bude sud ili posle 18. kada ona će vratiti.
Oh, you're muted, Mr. Schaefer.
Apologize. So, Your Honor, I think in a final pretrial, this case is either going to be dismissed or it'll take a plea to 769 4A. So I don't know that her appearance is necessary for that.
All right, so we'll excuse her appearance and we'll have it for June 27th at 8:30. Does that work for you, June 27th?
Kaže, 26. junija, to može za vas, dobro za vas? 26. junija.
That'll work for us. I have, that will be in the morning, is that correct?
Kaže, bit će ujutros.
If let's make that, if that's a plea, let's make it in person.
Sure, that's fine.
Kaže, to će biti in person, sve mora biti ovdje javno.
All right, so let's set it for June 27th at 8:30. We'll hold off on the jury trial date till we see.
Kaže, jun 26. at 8:30 će biti ovdje, da sud bit će ovdje.
So it'll be set for final pretrial on June 27th at 8:30.
Ovo bit će zadnja sudova data 26. junija at 8:30.
And that'll be live.
A i sve će biti ovdje, neće biti preko Zooma.
Anything else for the record in docket 2301-023, Mr. Brodowitz?
Nothing from the people, Your Honor.
Kaže, vi imate ništa da dodate, kaže, nema ništa.
Anything else, Mr. Schaefer?
Only that if Jeff agrees to dismiss it, I assume we wouldn't have to be present for that.
Correct. If Mr. Brodowitz dismisses prior to that, we won't have any need for the hearing.
Great, then we're done. Thank you very much.
All right. Go ahead.
Kaže, imate ništa dodate, kaže, a mi hoćemo da ovog slučaj bude dismiss, da ode, kaže, to će ako bude do 26. onda ćemo dogovarati.
So did your client get that?
Razumeli?
All right.
We're good.
All right. So that's all for the record, docket 2301-023. Thank you, everybody, for your appearance.
Kaže, ovo sve za danas za ovaj slučaj, onda doviđenja.
Thank you very much, Your Honor. And thank you to the translator.
All right, thank you. Ma'am, you're all set. Thank you for your assistance today.
No problem.
Okay.
Yes.
Rodriguez Morales file and see if an interpreter request was done.
What's
If
that?
the court was the one who asked for the interpreter, does the court need to
I need
sign her?
somebody, I need your signature.
Okay.
Yeah,
I was like, I
Nathaniel
don't
can,
think
yeah.
You can sign.
Okay.
3 and 2-2.
Also, Your Honor, I know we're not quite there yet, but since we have sort of a lull, as I believe the defense attorneys are meeting with their
Oh,
clients.
I
Mr. Jamie Soto scheduled for 9:30.
Okay,
I did not get a chance to, he's improper, it appears. And I did not get a chance to speak with him, but I did get a voicemail from him this morning. And I can play it for the court if the court would like to hear, but what the voicemail essentially said was that he was aware that he had court this morning, but forgot and was at work. And it sounded like he was not going to be here. So I just wanted to put that on the record, and then I was going to leave whatever discretion.
All right.
Whatever results to the court's discretion.
all right, when we get to that case, we'll address that. That's. You want to know if there was an interpreter on Rodriguez Morales?
Yeah, Lauren said he doesn't speak English at all.
And there is a request for it. D must provide, D requires Spanish interpreter. But I don't have, oh, I do have an interpreter Spanish.
One did not show up.
9. So, all right. That makes that case easy. We adjourn it for an interpreter. All right. Sir, on the Galaxy cell phone, would you identify yourself?
Good morning. My name is Kenneth Goodman.
Asante Parker.
Good. All right. All right, Mr. Goodman, stand by. We have some cases in front of you. Okay, sir?
Okay.
We have an interpreter and we're going on Ray W-R-A-Y. All right, so we're on the record in docket 23-01552. That is the people of the state of Michigan versus Robert Ray. So the parties, please introduce themselves for the record.
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Ray.
And sir, you are Robert Ray?
Yes, I am.
All right, this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer in this case that Mr. Ray would plea as charged with a killabrew to simply a weekend in jail in sentencing. So with that, I would leave it to the defense.
Ms. Robinson?
He's going to accept that offer today.
All right, Mr. Ray, that's your understanding. You'll be pleading guilty to the charge with the understanding that there's a killabrew agreement that you do 2 days in the Ingham County Jail. And that would be pleading to the charge of retail fraud in the second degree with a habitual notice or subsequent offense notice, making it a 1 year. Is that your understanding?
Yes, it is.
All right. All right. May So the offer is plea discharge, Killebrew. 2 days. All right, so Ms. Robinson, may I inquire of your client of his advice of rights?
You may.
All right. Mr. Ray, you understand in this misdemeanor case, the ultimate penalty, if I did not follow the Killebrew agreement, it's punishable by 1 year in jail and or $2,000. Do you understand that, sir?
Yes, I do.
If I deviate from that, you would have the opportunity to withdraw your plea. Do you understand that if I didn't stay with the 2 days?
Yes, sir.
All right. In concerning this case, you have the right to be, in this misdemeanor case, you have the right to be tried by jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by Erin Robinson, public defender, and she would be present. You have a right to counsel. She would be present to contest any charges or cross-examine any witnesses brought against you. Do you understand that, sir?
Yes, I do.
You'd have the right to have the court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right to have that, not to have that silence used against you, and you have the right to testify at trial if you choose to testify. If your plea is accepted today, you will give up the claim the plea was a result of any promises other than the stated plea agreement or threats that it was not your choice to plead guilty. Is it your choice to plead guilty today, sir?
Yes, it is.
All right. You'd also be giving up the right to appeal any trial rights since you won't be having a trial. You'll be pleading guilty. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, I'm going to bring your attention back to May 18th of 2023 at the offense location of 2400 East Michigan Avenue in the city of Lansing. Were you on East Michigan Avenue in the city of Lansing on May 8th, 2023?
Yes, I was.
And was Quality Dairy at the time at that location open to the public?
Yes, it was.
And what did you take from Quality Dairy without paying for it?
I know I can't exactly remember everything. Yeah.
All right. Did you take something
Yes.
from, you took something from Quality Dairy that was less than the price of $200?
Yes.
All right. And were you previously convicted of retail fraud third on March 21st, 2016?
Yes, I was.
All right. Any questions concerning the factual basis, Mr. Brodowitz?
Nothing from the people.
Ms.
Your Honor.
Robinson?
No, Your Honor, thank you.
I find the factual basis to be understanding, voluntarily, and accurately made. Mr. Brodowitz, did you want this sent for 3 cents for probation, or did you want to just go to immediate sentencing, or have we not had that discussion yet?
We can just go to immediate
Yeah.
sentencing.
Immediate sentencing?
Yes.
All right. So Mr. Neves, we're gonna take Mr. Ray into custody.
Well, he was doing a weekend.
So do you want him just to schedule it?
Yeah, so he could do it this weekend, that's fine.
All right.
But he's got an appointment on the 9th.
All
for a
right.
Doctor's appointment,
So let's do that. So what we'll do is I'll follow the recommendation, Killebrew 2 days. All right.
Thank you.
And does this weekend or next weekend? I don't want to get too far. So let's do it
He can do this weekend. It
All
would
right.
just, usually they report by like Friday at 5.
Friday at 5 until Sunday at 4 or something.
Yeah.
5. Okay. So what we'll do is we'll do a crime victims' rights fee, $75, a state fee of $50. Those I have to do. I'm going to waive fines and costs. And then we'll do 2 days in jail starting June 9th at 5 o'clock to Sunday, the 11th.
No, Sunday is the 7th.
Sunday's the 7th? It's the 11th.
Oh, you're right, it is.
Okay.
Sorry.
It's okay.
I thought you said the 6th.
I don't know how.
I was like, that's 6 days.
So June 9th to June 11th, I think that's at 5 o'clock also.
Yes.
Okay. So 2 days in jail. So pursuant to crime victims' rights and state fee, you're gonna have $125 charge on this. Do you need some time to pay that?
Yes, I don't have.
Yeah, let's do 30 days. All right. So
I had to make a payment plan.
let's do 60 days, and then you can make your own payment plan. All right. So we'll do 60 days. So the paid costs are due 60 days out.
Let's go from the first to
So-
next, like
so-
July.
Well, she's giving you August. 10th.
Yeah, so you can set up your own date. It's all due by August 3rd. The $125 is due by August 3rd. And then you can set up your own plan. Just come in and pay as we go, but make sure it's all paid by August 3rd, okay?
Yeah.
And you're to report to the Ingham County Jail by June 9th at 5, and you'll be released June 11th at 5, okay?
Yeah.
All right. Anything else for the record in docket 23-01552, Mr. Broadwood?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, you're all set, Mr. Ray.
Yeah.
June 9th is your date, okay?
Yeah.
All right.
Okay.
All right, we'll sit on. So let's go ahead and go on Mr. Soto. That's the one that you just indicated. We'll put that all on the record.
Okay.
All right, so we're on the record in docket 22-00036. People of the state of Michigan versus Jamie or Jaime Jesus Soto. Will the parties please introduce themselves for the record?
Jeff Brado, on behalf of the people, Your Honor.
All right.
Aaron Robinson, Assistant Public Defender for Mr. Soto.
And so are you on this case?
I am.
Okay. All right, so
I did
Mr.
not know that.
All right, so Mr. Brodowitz, it appears you didn't know he was represented.
No.
All right. And he did call you.
Yes, I printed out the docket yesterday, and yeah, just for the record, he called me this morning. I didn't know he was represented. I would have told you.
Okay.
If you want to hear the voicemail, I can play it for you.
So why don't you take some time to play the voicemail
Okay.
for Miss Robinson? And then we'll recall the case.
Okay.
So we'll adjourn that. Yeah, I have it as pro per also.
Yeah, if you want to.
Or you can take that out and play it for him.
Yeah.
I don't know if you want that on the record. We'll pick it up.
Yeah.
No, seriously, así los habla de insurance.
All right, so Ms. Steenbeck and Mr. Parker, I'm gonna put you in a breakout room with your lawyer, but we're gonna handle a couple cases here first. So we're on the record in docket 213-8858-8281. That's people of the state of Michigan versus Megan McGill Havlin. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. McGill Haviland, who's standing to my right.
And ma'am, you are Megan McGill Haviland?
Megan Ashley McGill Haviland.
Megan Ashley McGill Haviland, thank you. This is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer in this matter, which would be that if the defendant could provide a valid license, that the people would dismiss for compliance. After conversations with the defense, I believe the defendant needs time for that compliance, so I would leave it to the defense to make that motion.
All right, Ms. Sutter?
Thank you, Your Honor. I have expressed that offer to Ms. McGill Haviland. She is working towards that. She's already been in contact with the Secretary of State. She does have quite a few steps to go through, including getting her birth certificate, which my understanding is that takes a little bit of time. So if the court is amenable, I'm going to be asking for a little bit longer period of time than normal. If the court's willing to entertain 60 days for her to work on that, since it's going to take her a little time to wait for departments to get information to her, essentially.
All right, Ms. McGill Haviland, that's your understanding. We're adjourning for compliance purposes. 60 days is out there a little bit, but what it means is that after the 60-day period, I really can't adjourn it again. Do you understand that?
I completely understand. sir.
All right, so I'm gonna set it, so we'll set it for 60 days out. So sometime in August 6th, in the August 6th room.
August
8th, okay. So August 8th at 9 a.m. Oh, Ms. McGill Haviland, any paperwork that you have in order to make sure that Ms. Sutter gets it, all right? Because we may not need that hearing, but if we do have that hearing, make sure you come with any paperwork intact, okay?
Yes, sir.
All right. Anything else for the record? So you have that August 8th, that Ms. Sutter.
Yes, I do, Your Honor.
All right. Anything else for the record on docket 213-8858-281, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Sutter?
Nothing further. Thank you.
All right, Ms. McGill Haviland. We'll see you on that August 8th date.
Yes, that's not all my information there.
I definitely will.
And then I'm going to quickly grab Mr. Rodriguez Morales and his translator.
All right. I have two files. I should have two, right? Three trial and motion.
That's right. I think it's just one file. with
Yeah, it's
two
just one,
files.
two, that's.
Mhm. If you see this flashing, let me know, and if I don't see it.
All right, Mr. Parker, we're going to place you in a breakout room with your lawyer, and then followed by, we're going to place Ms. Steenbeck after that with Ms. Sutter, okay?
Yes, sir.
All right, thank you.
Hello?
Just a second, Mr.
Mr. Oakes, what case are you here on?
I'm here on
Christopher.
behalf of Christopher Hurt in place of Edward Zaney.
Mr. Oates, do you expect Mr. Hurt to be here today?
Yes, he's appearing over telephone.
All right, perfect. And once he gets here, I think we have everything. We can go ahead and put your case on the record.
Okay, thank you.
Mr. Williams, you're here on Mr. Hedrick.
That's correct, Your Honor.
All right. We're going to call a couple cases before yours, and then we'll call your case in just a minute. And I think we have everything for that file. All right, so we're on the record in docket. Mr. Schuff. All right. Docket 22-01797. That's people of the state of Michigan versus Stephen Schuff. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Schuff.
And sir, you are Stephen Schuff?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer for Mr. Schuff to plead to an added count 2 of trespass with an agreement to pay restitution. And with that, people will dismiss count.
Is that your understanding, Ms. Robinson?
That was the offer that was conveyed. At this time, I believe there's some possible competency concerns, so I'm going to ask for a reset date. Looks like a competency petition was already filed in another case that's pending in 54B back in April. So I am trying to follow up with them and check on the status of that.
All right. So if competence already been filed, we'll set it out 30 days.
That should be sufficient.
Right. So we'll adjourn 30 days. Do you know if he's been evaluated and they're waiting for a report, or is he seeking
I
evaluation?
don't. It looks like that's when the petition was filed, so it should be done sooner rather than later. He also has an outstanding felony as well. And so I'm not sure if the felony attorney maybe wants to file on that, try to speed things up. But I mean,
right.
We'll get to the bottom of it one way or the other.
All right, so we'll adjourn for 30 days for competency review, really just on another file. I can't even read that note. We'll set it for 30 days out.
July 18th.
July 18th at 9 a.m. So anything else for the record, docket 22-01797, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, you'll get notice for that July 18th date, okay, sir?
Yep.
All right, thank you.
We're all set?
Let's go on. Mr. Williams is here on Mr. Hedrick. I think we have everything. Let me make sure that.
If you want to see, there's nothing to really see. I'm not sure.
This is on. All right, Mr. Williams, we're ready on your file.
Good, thank you very much.
All right, so we're on the record in docket 14-00500. That is people of the state of Michigan versus Todd Hedrick. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Richard Williams on behalf of Todd Hedrick, Your Honor. Mr. Hedrick seated
right.
to my right.
And sir, you are Todd Hedrick?
Yes, sir. Yeah, yes, Your Honor.
All right. Thank you. This is the time set for a motion to set aside an application for conviction. Just for the record, I will indicate that the Attorney General has filed no objection on their opinion, and I do have an order. Mr. Williams, would you like to proceed?
Thank you. I'd like to ask Mr. Hedrick about whether or not this is his only conviction outside of the state of Michigan as well as here. Mr. Hedrick, have you any outstanding tickets that haven't been resolved yet? No, I haven't. Is there anything that is in any other area that is potentially pending? No. And Mr. Hedrick, are you presently employed? Yes. Whereabouts? Michigan State University. I see. Now, This happened back in 2014 on the conviction on the 8th day of April of 2014.
That's right, yes.
And the conviction was a misdemeanor operating with a high BAC.
That's right.
And you were before Judge Olison at that time?
Yes.
And again, has anything happened that we should know about that hasn't appeared on any record?
No.
Your Honor, anything further you'd like to ask?
Thank you. Mr. Brodowitz, any objection to the court signing the order for application to set aside the conviction?
People have no objection. Your Honor.
Okay. Without that, the order to set aside the conviction, I've checked boxes for the record. The boxes have previously been checked, but the main ones are 11, the attorney, an opportunity has been given the attorney general and prosecuting officials to contest the application. 12, circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application warrant set aside the conviction. And then 14, the application is granted. I will sign that for the record. And you should be all set, Mr. Williams. Anything else on docket 14-00500?
Nothing further. Your office is going to send it over to the state police. Is that correct?
I don't believe so. We haven't in the past. I can give you our contact. I can give you the court's contact person who handles this.
That would be good.
Yeah, I think. What's his last name? Farnham. I believe Sean Farnham will send it back to you, and then your client takes it to the state police. At least that's been the process before.
Thank you. Each court does it differently, so if I could get a certified copy of that, I'll have one of my people go and deliver it to the Canal Road State Police Post.
All right. What you should get a copy from Sean Farnham.
Sean Farnham.
Yeah. So that's FARNUM.
Okay, and Sean is with your office.
Yeah, he's with the city of Lansing, and he handles all the applications to set aside. He's the person to call on the file.
Fair enough. Thanks so much. It was I can't really see you behind that monitor over there, but I'm looking forward to seeing you one of these days.
All right. Thank you, Mr. Williams. I appreciate that. Take care.
Thank you. Bye-bye.
What's up, man?
And Mr. Samores, are you ready on your Mr. Holbrook?
Yes, Your Honor.
Right. We'll try to be not as entertaining as yesterday.
Well, I know my client wasn't there. I did not fill him in on it, but it was. Anyway.
I know, but you should have seen the look on your face was priceless, Mr. Samores.
Oh. I'm just glad it wasn't from my computer, but I hope whoever got hacked.
It was definitely not from your computer. It's unfortunate that it was from my computer.
Okay. Oh man.
I shouldn't say that. It was from somebody's computer, but it was on my Zoom courtroom.
Got it. Well, and I guess once you have a Zoom number, I guess it's probably like an easy hack.
It is not a difficult thing to go through, but we are taking precautions as to how generous we are with letting people in the room.
It's probably a great idea. Yeah, that was something. First time for everything. I remember I thought the most wild thing up until that moment was I was on a Zoom, a bunch of other attorneys were on it, and one attorney kind of fell asleep waiting, but that was like okay, a chuckle, but this was
yeah, this was far from a chuckle. All right. Mr. Brodowitz, are you ready on Mr. Holbrook?
I believe.
Or did you need to speak?
I just wanted to speak with Mr.
All right.
S'mores.
So, Mr. S'mores, I'll put you in a breakout room with the assistant prosecutor in a second, okay?
On Ms. Steenbeck and Mr. Parker.
Very well.
All right.
Thank you.
All right. And then, so let's go on Mr. Parker.
Ms. Steenbeck.
All right.
And then Mr. Parker is ready next.
All right. So we're on the record in docket 23-01473. That's People of the State of Michigan versus Sarah Steenbeck. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Steenbeck, who joins us via Zoom.
And ma'am, you are Sarah Steenbeck?
Yes, I am.
All right, this is the time set for pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have made an offer for the defendant to plead as charged to domestic violence with 76948 if eligible.
And Ms. Robinson?
I have conveyed that offer to
Oh,
Ms.
Ms. Sutter, I'm sorry.
That's okay. I've conveyed that offer to Ms. Steenbeck. At this time, we would ask the court for a final pretrial.
All right. So we'll set it for final pretrial and corresponding jury trial date, final pretrial date of
6/27 to 8:30.
6/27 at 8:30,
And the trial will follow on July 18th.
July 18th at 8. Final pretrial is live. And of course, the jury trial is live. So Ms. Steenbeck, you have that date of July 27th at 8:30?
Okay.
All right. Anything else for the record? And I have indicated that an offer has been made. Anything else for the record? Docket 2301473, Mr. Brodowitz.
Nothing from the people, Your
Ms.
Honor.
Sutter?
Nothing further, Your Honor.
All right, Ms. Steenbeck, we'll see you on the June 27th date, okay?
Okay, thank you.
right?
You're all
That would
set.
make sense. But one time, when you have.
I can leave the room?
Yes.
Yes, you
Okay,
can.
thank you. Bye-bye.
We're gonna mute that guy. All right, and then Mr. Parker. We're on the record in docket 2301111. That is people of the state of Michigan versus Asante Parker. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Parker, who joins us via Zoom.
And sir, you are Asante Parker?
Yes, sir.
Okay, you can hear me all right, Mr. Parker?
Yes, sir.
All right, this is the time set for a pretrial on the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. As you stated, today's a date and time set for pretrial. We were here a couple of weeks ago on the same matter, and it was Mr. Parker said that he no longer had the dog in question. Through Ms. Sutter, he has provided proof in the form of a letter from the new owner of the dog with contact information. And so at this time, the people, I guess, would seek to dismiss because Mr. Parker no longer has the dog.
All right, is that your understanding, Ms. Sutter?
It is, Your Honor, and I have no objection.
Let's see, this is on a ticket, okay. So this is dismissed pursuant to the people's request and defense is no objection. As to the file 2301111, people to move to dismiss without prejudice is granted. Mr. Parker, you should be all set today, okay, sir?
Thank you, sir.
All right. Anything else for the record, docket 2301111, Mr. Brodowitz?
Nothing from the people.
Ms.
Your Honor.
Sutter?
Nothing further. Thank you.
All right, Mr. Parker, thank you for your appearance. You're free to leave the Zoom courtroom.
Thank you, sir.
On the cell phone, 2453, would you identify yourself, please? And you'll have to unmute yourself.
Mr. Hurd.
2453 on the cell phone.
Mr.
How about
Hurd.
individual on the cell phone 9969? Can you identify yourself?
This is Spencer Gerber. I'm calling in for Bulldog Rentals versus, I believe it's Alberta Gregory, and there's another individual as well.
Oh, okay. You're here for your 1015?
Yes. Oh, yes. Yep. 10:15. Yep.
All right. We got a few cases in front of you, but stand by. You're in the right place. All right, sir?
Perfect. Thank you.
All right. And then individual ending on the cell phone 2453, you'll have to unmute yourself. Can you identify yourself?
It is Mr. Christopher Hurd. I don't know why he's not hearing us now.
All right. So that is Mr. Hurd.
It is.
Can I get some more?
All right. We're gonna put our assistant PA. See if he can unmute himself, Mr. Oakes.
Okay. Mr. Hurd.
Yes, I'm here.
All right. Thank you, sir. We're going to call your case in just a second. You're in the right place. Just recognize the courtroom can hear you. Once the assistant gets back, we'll call your case. All right, sir?
Okay, I was trying to log in. It wasn't letting me.
All right.
Kept saying
Well,
I had to unmute.
all right. You were supposed to be Mr. Oaks. We'll call your case in just a minute.
Okay, thank you, but I am here.
Hello?
Hello?
Hello.
Hello?
Can
I'm
you
here
see
for
me?
All right,
a quick,
Mr. Sundin, I think we can call your cases.
Okay.
All right. So we're on the record in docket, excuse me, 23-01017. That's Richard Sundin versus Carrie Mack. Will the parties please introduce themselves for the record?
This is Richard.
And sir, you are
Sundin,
Richard
landlord.
Sundin? Go ahead.
Yes.
All right. This is the time set for a terminacy of tenancy hearing. We had previously scheduled for May 24th. The defendant failed to appear. We had subservice, service by subservice, so set for second hearing, which is today. It was scheduled for 10 o'clock. It is now 10:22. It would appear that Ms. Mack has failed to appear for the second hearing. And Mr. Sundin, I'm assuming you're be requesting a default judgment?
Yes, sir.
All right. Do you have any numbers that you'd like to place on the record?
Numbers pertaining to balances owed?
Yeah, that's correct. Or you can just follow it up with an order for the court to sign.
Yeah, I think I'm gonna have to get the current balance, actually.
All right. If you go to the civil department, they have an order and a default judgment order, and you can fill that out and forward it to the court, and then this will take effect on the date of the signing.
Okay.
All right. So that's all for the record. I'll indicate the order to follow. That's all for the record in docket 23-01017. And then we're on the record. Go ahead, Mr. Sundin.
Will that be a physical document I need to obtain, or do I phone that in?
Yeah, that'll be a physical document that I have to sign.
Okay, default judgment order.
Right. If you tell them what happened, or if you go to the website, the landlord tenant website, they'll have an order and default judgment that you'll have to fill out and make sure to forward to the landlord tenant civil department so they can present it for my signature. This won't take effect until I sign.
Okay, good.
All right. So let's call your next case of 23-01018. That is also Richard Sundin versus Nicole Fernandez. This is set for the second landlord tenant hearing in regards to termination of tenancy. Mr. Sundin, your appearance for the record.
Richard Sundin here, landlord.
All right, this was the time.
I'm sorry to interrupt you. I actually just found the record of balances, so I do have those numbers. So.
All right, you can follow that up with an order. Just make sure the order has any type of balance. Put in for me to sign.
Okay, I'll do it that way. Thank you.
All right. So so this is on docket 23-01018. This is previously scheduled for May 24th, in which the defendant failed to appear. There was service by attachment. We've set it for a second hearing today, June 6th at 10 o'clock. It would appear that the tenant has failed to appear at the second hearing. This was scheduled for 10 o'clock. It is now 10:25. And Mr. Sundin, as in the previous file, my assumption is you're requesting a default judgment?
Yes, sir.
Okay. As the last file, the order would be to follow. And so if you follow up with an order concerning the numbers in regards to this tenant, the court will sign the default judgment. Okay, sir?
Okay. Yes, sir.
All right. So so that's all for the record, docket 23-01018. And then we have one more file. And that is docket 23-01019. It's Richard Sundin versus Emma Hoover and Kelly Anderson. Will the parties please introduce themselves for the record?
This is Richard Sundin, landlord.
All right. So this is time set for a landlord-tenant hearing on a terminancy tenancy. There was an indication that we had a prior hearing on May 24th, 2023. There was personal service to Emma, but sub-service to Kelly. We set both for June 6th today in regards to both defendants failed to appear on May 24th. It would appear that tenants 1 and tenants 2 have once again failed to appear. I do not see a Emma Hoover or a Kelly Henderson in the Zoom courtroom. There's nobody by that name in the physical courtroom. This was scheduled for 10 o'clock. It is now 10:27. And Mr. Sundin, I'm assuming as in the last files, you're going to be requesting a default judgment?
Yes, sir.
All right, that default judgment is orally granted. The order is to follow the file. And so when that order to me for signature, you should be all set today.
Okay, do I need to get this additional paperwork submitted for signature in order to act on the eviction?
Correct. So I will have to sign the default judgment and the order, and then it'll be 10 days from the date of signature that you can actually apply for an eviction notice.
Okay, I'd like to.
All right.
I'd like to give could I give a number for you for the first one, Carrie Max, so that I can get that signed now? That is the one I would like to be able to act on within 10 days.
The only way you can do is to get me an order. So fill it out as fast as you can and get me an order to sign. Because orally, I can only orally order it, but it actually takes in effect when I sign it, and it's 10 days from that date. So get it to me as quickly as you can.
I have the balance owed for that one here in front of me. Can I give you that number?
Then make sure that you put it on the paperwork for me to sign.
Oh, I see. We can't do it now. Okay.
Yeah, I can't do it orally. I can only do it by signature.
Okay, can do.
All right. That's all for the record, docket 23-01019. Did you have any questions, Mr. Sundin?
What is the website for getting that paperwork?
It's the City of Lansing website. It will be the landlord tenant section.
54A district.
That's so
court.
54A District Court.
Okay, thank you very much. That's all for now.
Thank you.
Bye-bye.
And then Ms. Freeman, what case are you here on?
Your Honor, it's Bulldog Rentals LLC versus Gregory, 23-1205 DE.
All right. Are you here for Fountain Place also, or is that a different Freeman?
No, Your Honor, I'm not.
All right. All right, 205. All right, we can go ahead and call that. Somebody was here on that case previously, though.
It's just a property.
Oh, it's just the property manager. All right. So we're on the record in docket 23-01-205. That is Bulldog Rental LLC versus Alberta Gregory and Richard Gregory. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Attorney Carrie Freeman appearing on behalf of the plaintiff Bulldog Rentals LLC. My representative client Spencer Gerber also appears to be here on the Zoom call.
All right. This is the time set was for 10:15. It is now 10:31. And I do not see Alberta Gregory or Richard Gregory in the Zoom courtroom. There's nobody by that name in the waiting room and nobody in the physical courtroom. So at this point in time, it appears the tenant 1 and tenant 2 have failed to appear. I will indicate that we did meet on May 24th, 2023 for the first hearing. We had service by attachment. There was a fail to appear on that date. Ms. Freeman, how would you like to proceed?
Your Honor, I emailed this morning proposed default judgment to the email address for your courtroom. And I'd like to request a default possession judgment be entered. And I can provide the amounts if you'd like right now. And then as far as the money judgment is concerned, we'd like to sever and adjourn that for personal service on the defendant.
All right, perfect. Do you want to put your numbers on the record?
Yes, I would like to. And again, you should have this in your email, but as far as the possession judgment is concerned, Your Honor, for rent to retain possession as of June 6th, they owe $2,813.70. Other money due is late fees in the amount of $150. There were costs in this matter in the amount of $240.93, and this all totals $3,204.63. We're requesting the possession judgment with a writ date of June 16, 2023, and again, with the money judgment being severed and adjourned for both defendants to potentially obtain personal service.
All right, thank you. To the best of your knowledge, the Alberta Gregory or Richard Gregory are not a minor, incapacitated, or in the military service?
To the best of my knowledge, no, they're not.
All right, and and to the best of your knowledge, the premises was kept for its intended purpose.
Yes, Your Honor.
All right, and you've already followed that up with an order. We just have to pull it off oh, here it is right here. Hey, look at that. So so with that understanding, I will sever the money judgment for personal service. Okay. And based on the numbers you've indicated and the date, I will sign the order to that effect. Anything else for the record, docket 23-01-205, Ms. Freeman?
No, Your Honor. Thank you very much.
All right, you're all set. Thank you for your appearance today.
Take care. Have a good day.
You too.
Hi, Mr. Flores.
Ms. Holmes? Yes.
Just wondering if I'm supposed to be here. It was at 9:30. I didn't know if you guys were running late or not.
You're represented by counsel, Ms. Sutter. We verified that. And so if you stand by, I'll wait to hear from her concerning what we're doing with your case. You may be meeting with her in a second. Okay, ma'am?
Yes, sir. Thank you.
All right. You're welcome. And Miss Watkins, you're here on Matthew Warner?
Yes, Your Honor. Good morning.
All right. All right, so we're on the record in docket 23-01063. It's Elena Watkins Living Trust versus Matthew Warner. Will the parties please introduce themselves for the record?
Elena Watkins.
All right, this is the time set for terminacy of tenancy second hearing. I do not see Matthew Warner in the Zoom courtroom. There's nobody by that name in the physical courtroom. For the record, this was scheduled for 10:15. It's now 10:35. Previously, we met on May 24th. The defendant failed to appear at pre-trial. This was set for second hearing. We had service by attachment. Ms. Watkins, I'm assuming you're requesting a default judgment today?
Yes, I am.
And did you have any numbers you wanted to place on the record, or you're going to follow that up with an order?
I just want to terminate the tenancy.
All right.
Take
So
my
this
property
is for,
back.
this is possession only. It's
Possession.
my understanding, to the best of your knowledge, Ms. Watkins, that Mr. Warner is not incapacitated, a minor, or in the military service.
Not, Your Honor.
All right, and the residence was kept for its intended purpose.
Yes.
All right. Well, then I will await you to follow up with an order. So the orders to follow. And this will take effect once I sign the order. All right, ma'am?
All right.
All right. Anything else for the record, docket 23-01063, Ms. Watkins?
Not. It's not.
Okay, you're all set, ma'am. Thank you for your appearance today.
Thank you, Your Honor. Good night. Goodbye.
I had to wait for an hour.
Mr. Miyagi, what case are you here on?
Actually, my name is Christopher Herr. That's just my phone name.
Okay, you're Christopher Herr.
Yes, sir.
All right. All right. And so, Mr. Oakes, that's your client, correct?
That's correct, Your Honor.
All right. Once we track down our APA, we'll start calling some cases related to our criminal cases.
Okay.
Miss Austin, you're the property. Are you the Oh, you're the for Freeman for Fountain Place, Miss Austin. Is that correct?
Yes, Your Honor.
All right. I'm pretty sure we can go ahead and call your case.
Okay, perfect.
Did you have a question for me?
Just, you guys keep talking during these Zoom hearings, so I'm really badly trying to hear what the people on Zoom are saying over what you and Ms. Robinson or Mr. Brodowitz have been talking about today.
Sorry.
All right, so we're on the record in docket 23-01034. That is Fountain Place Limited versus Kanji McQueen. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Rebecca Austin, appearing on behalf of plaintiff.
All right, this is the time set for a non-payment on a landlord-tenant matter, and this was set for 10:15. It is now 10:39. It would appear that the tenant has failed to appear. I do not see a Tangi McQueen in the Zoom courtroom. I see nobody by that name in the physical courtroom. I would indicate that on May 24th, we had a first pretrial, a first hearing. that the tenant failed to appear for, so we set it for second hearing because of service by attachment. Ms. Austin, how would you like to proceed?
Your Honor, I would ask for a default judgment.
Are there any numbers you'd like to place on the record, Ms. Austin?
Yes, Your Honor, there is rent to retain is $1,754.91. There are court costs of $155. The total then is $1,909.91. We're requesting a possession only judgment. Upon information of belief, Ms. McQueen is over the age of 18, is not in the military service, is not otherwise incapacitated, and that these premises were kept fit for the use intended and have been in reasonable repair.
All right, thank you. And you'll follow up with an order to that effect?
Yes, Your Honor. And I would request a writ date of, June 16th.
June 16th, okay. All right, I'll wait the order to follow and sign it per default judgment. Anything else for the record, docket 23-01034, Ms. Austin?
That's it for me, Your Honor. Thank you so much.
All right, thank you. You're all set.
Thank you.
Lost her. Mr. Samores, are you ready on Mr. Holbrook, or did you need to speak with this APA one more time?
No, I think we're okay, Your Honor. I don't know if there's a way for Mr. Brodowitz and I to approach, and I definitely have my client leave my office. He is here for the record. Just a couple.
I don't know if there. I don't think there's a way by Zoom because I can't. I can't.
Okay.
I can't. Yeah.
Okay.
He's gonna see if there was a way to approach us, and there's not.
I mean, we could go into a breakout room and then go into your office, Your Honor.
Yeah, but then I still have the Zoom courtroom, and I still get on Zoom in my office.
No, I could bring my computer in a breakout room.
I don't know if that's necessary for pretrial. Do you?
Okay. I can voice my concerns on the record. That's fine, Your Honor.
All right. So let's go ahead and call docket 23-01356. That's People, the State of Michigan versus Timothy Holbrook. Will the parties please identify themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Peter Samoris here on behalf of the defendant, who is also present via Zoom and in my office, physically
And
next
sir,
to me.
you are Timothy Holbrook?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Holbrook?
Yes, sir.
All right, this is the time set for a pretrial on this matter. Mr. Brodowitz, I'll hear from you, and then Mr. Samoris, how are we proceeding today?
Yes, Your Honor. And in my discussions with Mr. Samoris, I believe we had discussed an offer of, and I guess it would be in this, I'm not sure exactly how the court works since this started as a felony file. I guess would be an added count 3 of disturbing the peace with an order or an ask for immediate sentencing, and then even just simplifying agreement to fines and costs on this, or no upfront jail. There, it was kind of there was some of the ideas thrown around. I'm not sure. Mr. Samoris said he was going to speak with his client. I'm not sure how he and his client have decided to proceed in this, so I would leave it to him with that.
Mr. Samoris, so the offer's been extended today. How did you want to proceed? Did you want to set it for plea? Did you want to address this today? I do understand this was originated as a preliminary examination, so I understand that this is kind of changed during the race.
That is understood, Your Honor. Thank you. And that is a correct statement. My client is definitely inclined to take it. And one concern that Mr. Brodowitz and I talked about was that because it's originally an assaultive crime, and I'm not trying to be a cog in the wheel here by any means, but it's my understanding Miss Alma Robinson would be required to get notice. I know it's my understanding she does have notice of this pretrial and perhaps a possible resolution. And of course, this amended charge is not assaultive, so it's been a while since I've looked at the victim's rights statute in that regard. But I would just state, Your Honor, another consideration is if the court would be inclined to accept a no contest plea, or I suppose because it's a lesser charge, if Mr. Brodowitz would agree to it, and the reason being civil liability. In fact, as I speak, and I do not represent Mr. Holbrook in this, but a landlord-tenant eviction process has already begun, for example. And
well, why don't we do this? Since and Mr. Samoris, you know better, but if this is the offer made today for disorderly, then we could set it for plea and then have whatever no contest factual information or factual basis used in order to use as a basis. It sounds like civil liability would be an appropriate reason for the no contest plea.
Okay.
And then that would suffice for any notice or lack thereof concerning the plea. If Mr. Brodowitz told the victim to be here regardless, he can explain to the victim the plea offer. But right now, it would be a no contest to my understanding, a no contest to disorderly, and then go to immediate sentencing.
Yes, that would be my understanding as well, Your Honor. And I've got my calendar here, so I don't know if I should get a date right now.
Yeah.
Okay.
Yeah, let's get a date and that fits with your calendar in regards to the no contest plea. So we'll set for no contest plea, and let me get some dates, and then we'll see how those dates work out. So how does June 27th work?
If it's in the morning, and especially if it's by Zoom, and no problem. I just have one matter that I can't miss in the afternoon that's in person.
So I think you said morning? Yeah. So could we do June 27th? If it's a no contest plea, it'll make it easier if we have the police report in hand or whatever. So June 27th at 9:30?
That's fine, Your Honor.
All right. June 27th at 9:30, that'll be live, and the parties can come up with a factual basis for the no contest plea. Any questions, Mr. Brodowitz, about that June 27th date?
Nothing from the people, Your Honor.
All right. There's also, I have a PA 53. Okay, let's just set it at the same time, all right? The PA 53, we'll just set it at the same time, and we'll resolve that, so it's all resolved together.
Okay, thank you, Your Honor. So I would, just to be clear, I'm noticing it on or not noticing it on myself, but this would be a no contest plea, immediate sentencing, So any notices to Ms. Robinson would be, I'm sure would be fulfilled, and that would not, I just don't have to be an issue in any way. That's all.
Right. Mr. Brodowitz will provide the victim any notice, and you're set for June 27th at 9:30.
Thank you very much, Your Honor.
All right, thank you. That's all for the record docket 2301-356. Take care, Mr. S'mores.
Thank you, Your Honor. Likewise.
We may be able to go by Ms. Rouse.
All right, we also have her here. Mr. Oaks is here on her.
Should be black, red.
Wow.
Her middle name is Coy.
Yeah, I think they're about to come on, but I don't know.
Stand by, Mr. Herr. We're still waiting for a couple lawyers, okay?
Okay, thank you.
Leave it blank like this.
No, I can make this black. And then I could do that with the red too.
Yeah.
He's on Zoom?
Yes.
All right. So we're on the record in docket 23-01362, 63, and 64. That's people of the state of Michigan versus Kenneth Goodman. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Goodman, who is joining us via Zoom.
And sir, you are Kenneth Goodman?
Yes, sir, I am.
All right, this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, after conversations with the defense, an offer was made that Mr. Goodman would plead to count one of dog at large with an agreement to pay restitution on a deferred sentence on that case, and then the people would dismiss counts 2 and 3. So with that, I would leave it to the defense.
All right, Ms. Sutter?
Your Honor, I did express that offer to Mr. Goodman, and he is amenable to it. I did ask for what the restitution amount is to convey to Mr. Goodman if we want to accept the offer today and just wrap everything up. However, Mr. Brodowitz advised me that the complaining witnesses in this matter tried to provide him with receipts last night, and he told them not to.
All right, so let me make sure I got the offer correct, and then we can go from there. The offer is to plead to one file and dismiss the other 2 files, or?
Correct.
Yes, Your Honor.
Okay. So there's 2 dog at larges and a dog bite.
Correct.
And the offer is to plead to count 1 and dismiss count 2 and 3?
Correct.
All right. So let me make sure I've got this. So offer is plead to this charge, dismiss for negotiations, and dismiss per negotiations. Now, dog at large is a 90-day and/or $200.
1 second, Your Honor.
Just so we're clear. Or is it $100?
There we go. Try to find it, Your Honor. It's 90 day, I believe, but I don't have that fine written.
I believe it's 90 days. I just don't know what I don't know if it's 100, 200, 300.
Dog at large is a 90-day and/or 500.
90-day and/or 500. And it's my understanding that so it would be a deferred sentence for restitution purposes. Is that correct?
Correct.
Yes.
And if restitution was made at the end, count 1 would also be dismissed.
Yes.
Count would also be dismissed. But we don't know what the restitution is.
At this point, no, Your Honor. My plan was to get the restitution amount from the victims today, and then provide it to the defense at the time that the sentencing was done.
Just so we're clear, Your Honor, we could have had it today already had Mr. Brodowitz not told the complaining witnesses not to send it.
Let's do this. I mean, just to be safe.
If the court's amenable,
Set it for plea, and then have restitution as a part of the plea, so that everything's taken care of at once. The restitution's here. You have a number. Mr. Goodman has a number. He pleads and then actually it's just a dismissal of all 3 counts, isn't it?
if the payment is made, yes. Would the court entertain hearing it this afternoon if Mr. Brodowitz is able to get that information to me?
Find it this afternoon. Probably not. Looking at the court schedule. I don't know if you'd have time, Ms. Sutter.
Fair.
Yeah, I don't know if you'd have time looking at the court schedule. But I would entertain a quick turnaround if we're just setting it for plea with restitution as part of. So the plan is all 3 files are dismissed if restitution is made.
Well, 2 would be dismissed upon the original plea. The last would be dismissed upon finishing of the payment.
Okay.
Yes.
So could we take the plea today, dismiss counts 2 and 3, and then set it for restitution hearing.
I'm a
So
little
that-
hesitant to do that, Your Honor, until I know the number that's being.
Right,
communicated here.
that would be my fear. My fear would be, without a number up front, you'd be looking at account one, and then you'd have some number that you didn't
Right.
anticipate.
Because I don't know if it's 100 or 1,000.
Right,
And it
right.
really does make a difference.
Well, let's set it for plea then.
Okay.
Yeah, let's set it for plea. So, Mr. Goodman, you understand what we're talking about. In order to plead to one of these, and this is kind of deferred, but what it's important that you have a number that you're looking at before you plead to anything. Do you understand that, Mr. Goodman?
Yes, sir, I understand, Your Honor.
All right. So we'll set it for plea.
June 27th at 9:30 is our next available with Ms. Sutter's schedule.
Is there any way it can be heard next week? And I think Ms. Robinson or Ms. Wicks would be amenable to handling that for me.
Yeah.
I appreciate the looking out for my schedule, Wendy.
1 second, let me see what we.
So, because you're at conference, so but
Correct.
definitely could get coverage for this.
Yes.
Okay, so you want to do September?
No, thank you.
I'm sorry. No, thank you. June 13th. June 13th at 8:30.
And you said that's for a plea date is what you're scheduling for your.
Yeah. Plea date and restitution to be determined by that. 8:30. And so you understand the nature of the offer, Mr. Goodman. You should get a full number, and you'll be represented by the Public Defender's Office, June 13th at 8:30. And you can do that by Zoom if we can do that all by Zoom. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 23013626, 63, or 64, Mr. Brodowitz?
Nothing from the people. Your
All
Honor.
right, Ms. Sutter?
Thank you, Your Honor.
All right, you're all set. Thank you for your appearance and your patience, Mr. Goodman.
All right, thank you, everyone. Have a good day.
You too.
Thank you, Mr. Goodman. And Ms. Holmes is also ready, Your Honor.
All right. All right, we're on the record in docket 23-01386. That is People of the State of Michigan versus Stacy Holmes. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Holmes, who joins us via Zoom.
And ma'am, you are Stacy Holmes, and you'll have to unmute yourself, ma'am.
Yes, sir.
All right, this is the time set for, and you can hear me all right, Ms. Holmes?
Yes, sir.
All right, this is the time set for a pretrial in this matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After conversations with the defense, I believe we have come to an agreement in this matter, and that would be for the defendant to plead to an added count 2 of operating while impaired by liquor, which is under the driving code, and that would be under 257.625 parents 3.
And that's 92 days and or
93 and or 300.
93 days and or 3 and or
And or 300.
300. And that's your understanding, Ms. Sutter?
It is.
All right. And Ms. Holmes, you're prepared to enter a plea to that offense?
Yes, sir.
All right, Ms. Sutter may inquire of your client of their misdemeanor advice and rights.
Yes, Your Honor.
All right. So you understand, Ms. Holmes, that the maximum penalty the court could sentence you to is 93 days and or $300.
Yes, sir.
All right, and this would be an added count 2. You understand that in regards to that added count 2, you'd have the following, you'd be giving up the following trial rights if you pled guilty today. One is you'd be giving up the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses against you. You, of course, are represented by Public Defender Lauren Sutter. She would be here to cross-examine any witnesses or contest any charges brought against you. Do you understand that, ma'am?
Yes, sir.
You'd also be giving up the right for the court to order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll claim the plea was a result of any promises other than the plea agreement or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal any trial issues. Since you are pleading guilty, you will not have a trial. Is it your understanding and your preference today to plead to count 2 operating while intoxicated by liquor?
Yes.
All right. All right, I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Okay, I'm going to bring your attention back to September 2nd, 2022 at the offense location of Martin Luther King. Were you driving a vehicle open to the public upon a highway on September 2nd, 2022 on Martin Luther King Boulevard?
Yes, sir.
Is this an impaired or intoxicated?
Impaired.
Okay. And at that time, did you recognize, were you over the blood alcohol level, or later learn you were over the blood alcohol level of 0.08, being in violation of 257.2653, or were you impaired while you were you substantially or affected impaired to operate the motor vehicle at the time?
Yes, sir.
All right. Any questions concerning the factual basis, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Sutter?
Nothing, Your Honor.
All right. I find the factual basis to be understanding, voluntarily, and accurately made, and I will refer this to probation. So, Ms. Holmes, you should report to probation, City of Lansing probation. Is she local?
She does live in the Lansing area. Your Honor.
Okay, so within 48 hours, so Thursday by 4.
Yes, sir.
Okay, what they're gonna do is they're gonna ask you a lot of questions and answer those questions and be as candid as you can, and we'll come back and we'll see what options are available for us at sentencing. All right, ma'am?
Yes, sir.
All right. We'll have a sentencing date of
July 25th at 1:30.
So sentencing date will be July 25th at 1:30. Okay. So go to probation within the next 2 days and they'll do a report, and then we'll see what options are available for us at July 25th at 1:30. All right, ma'am?
Now, is this back on Zoom, or do I have to come in person?
The sentencing will be live. Let's
Okay.
have the sentencing be live. All right, ma'am?
Okay, thank you.
All right. Anything else for the record in docket 23-01386, Mr. Brodowitz?
Just briefly for the record, Your Honor, because I believe I forgot to state it, with that plea to be added count 2, count 1, he would dismiss count 1.
And I'll indicate that for the file. Count 1 is dismissed.
Correct, Your Honor.
Anything else, Ms. Sutter?
I have nothing further. Thank you.
All right, thank you. All right, Ms. Holmes, thank you for your appearance. We'll see you on that July 25th date. Make sure you report to probation, okay, ma'am?
Okay, thank you.
You're welcome. I don't see Yaramawa.
It's no longer in Calhoun County.
Yeah, he's no longer in Calhoun County. We don't know where.
Don't know where he's at.
All right, let's go ahead and call that case then. We don't know where he is. Is that you, Ms. Sutter, or Ms. Robinson?
It's my case.
All right. So we're on the record in docket 22-03281 and 22-03434. That is people of the state of Michigan versus Karangwa Pararamana. And we didn't have we had an interpreter scheduled, but then I assume we called him off.
I did not call the interpreter off because I didn't know if he would come in by himself, so I think the interpreter off.
All right.
I'll get him responding.
All right. All right. So we're on the record on both those files. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Herrera-Mana.
Right, this is the time set for a pretrial in the matter. My understanding is that the defendant at one point in time on May 23rd needed to be writ out of Clinton County and an interpreter was needed for pretrial. It's my understanding that the defendant was let out of Clinton County prior to the any writ being performed for June 6th. So, Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor, as if that is in fact the case, then it appears that the defendant has not appeared today on his own, so the people would ask that a bench warrant be issued and any bond be forfeited.
Ms. Robinson.
Well, I mean, he doesn't have notice to be here today, obviously, if it wasn't, if he wasn't able to be
Yeah.
done. So I would just ask that we reset the pretrial and send notice to his last known address.
Yeah, he was noticed to his last known address.
Okay, so that was sent.
Yeah, that was sent out. So he was sent to the Green Lawn Avenue address on for pretrial on June 6th. But I do understand that I don't know if he still lives at address. My indication would be to allow for a 48-hour hold, defendant bench warrant bond forfeiture with a 48-hour hold, which would allow him to bring himself in if he can make contact with the public defender's office or this office. Any response to that, Ms. Robinson?
No, that's fine. I have no objection to that.
All right. So I'm going to have defendant failed to appear. Bench warrant and bond forfeiture. I have no previous fail to appears. I do have a previous fail to appear on the interpreter. So
yeah.
So evidently that's an issue, but defendant failed to appear, bench warrant forfeiture with a 48-hour hold. All right. So with that understanding, there's a 48-hour hold placed on the bench warrant and bond forfeiture. Anything else on docket 22-03-434 or 22-03-281, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right. Anything, Ms. Robinson?
No, Your Honor, thank you.
All right. We're all set on those two files.
We can go on. You said Alford was here?
I don't think Mr. Alford's here. He's not in the Zoom courtroom. Let me do Mr. Herr, because I know Mr. Oaks has been waiting on Mr. Herr. And then
No, he's not here.
is there, and I don't think anybody's here on Nance either. That was a clean slate when you asked me about Mr. Brodowitz. All right. So Mr. Oaks, let's go on your case. We're on the record in, this was a application to set aside a previous conviction. People of the state of Michigan versus Christopher Lee Herr. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Mike Wilkes appearing on behalf of Christopher Herr.
All right, and sir, you are Christopher Herr? All right.
Yes,
and
Your
you can
Honor.
hear me all right, Mr. Herr?
Yes, Your Honor, I can.
All right, thank you. And I appreciate your patience in waiting for this matter. This is a motion to set aside the conviction. I'll indicate that Mr. Oaks is here for Mr. Zaney, was reassigned to this court from a sunsetting of Judge Felice's docket. The Attorney General opinion has been filed, and if it has no objection, as long as Mr. Herr meets the statute's eligibility requirements, and proof of service was filed. Mr. Oaks, would you like to proceed?
Yes, I'd like to make an oral amendment to the application, that being Mr. Herr had a conviction set aside this past Friday, June 2nd, 2023, for possession with intent to deliver marijuana in the 30th Circuit Court. In addition, Mr. Herr had a home invasion that was disposed of under HIDA. And all of that information was listed in his record search that was submitted to both the Attorney General's office and the prosecutor's office.
All right. My only concern on that is that the order does not reflect either one of those HIDA convictions. And so I don't think there was an objection to the order as it was, but I don't think that our order has neither one of those. And I'm reluctant to write those in regards to that. In regards to that, all I have is the note, and they are not convictions, but I don't know how I don't know how the order would reflect the two non-reportable, that's both HIDA conviction, one HIDA conviction and one non-reporting conviction, it looks like. So and Mr. Oaks, I know you're covering on this file. Could we reset this for a new order to be submitted to the court?
Okay.
Yeah, I think I would feel better about that, since the order that was submitted and the information doesn't have that on the original order, but I don't think it changes anything.
I agree.
Yeah, so.
How soon can we get it?
All right. All right, so we're gonna reset for a new order to be submitted with the additional information.
Could I say something, Your Honor?
You can, Mr. Herb. Just understand you are represented by counsel, but you can say something, Mr. Herb.
I heard something about a home invasion. I've never had one of those like ever in my life, sir.
Yeah, so I think that's why we want to do an additional order, just to make sure that the order accurately reflects anything that you've gone through, and you can discuss this with Mr. Zaney or Mr. Oaks, but that would represent, so that I know that I'm signing something that you're comfortable with.
And he's correct. It was an unarmed robbery that was disposed of under HIDA. So Mr. Herb.
Under YTA?
Yep, under YTA.
All right.
So Mr. Herb, what he's saying is, for those because you had that expungement that took place a couple of days ago on Friday.
Yes, sir.
You had this unarmed robbery. On the paperwork that we submitted on your behalf, we have to list that on the order for him to sign. So, it's not going to prevent us from you moving forward with getting this off your record. We just have to update the paperwork that was previously submitted to the court.
Okay, thank you, sir.
All right, yeah, because I'm assuming this is an operating by suspended license misdemeanor. So, but I'd like, if I sign the order, I'd like it to reflect the things that just previously happened in the last few days. All right, sir?
Yes, sir.
All right. We'll reset this. I think Mr. Farnham will probably reset it unless you want to.
I'm trying.
Okay. We're trying to reset it, but I think we get this from an individual who's assigned to on the orders and applications. I may give you a date, I may not.
All right, no problem.
I think I have it worked out. I just need to do some mumbo jumbo pushing.
Okay, so what's the date?
June 27th at 10.
All right, so we'll set this for June 27th at 10 a.m.
All right, thank you.
All right.
Thank you, Your Honor.
All right. All right. And I'll have we'll renotice this out, but you have notice of June 27th at 10 a.m. and then I'll have Mr. Farman resend it out, okay?
All right, thank you.
Thank you. Thank you for your patience today.
Yep.
Thank you.
I just said, Sean, if you have any questions, see me. Yeah, just, I know, well, I kind of got that. All right, and let's do Miss Nance, Valenta Nance, and then we'll go on to our last case, I think. All right, so we're on the record. This is Alfred too. Those two are Alfred sentencing. I thought, oh, we're still waiting on him.
Yeah, he was second.
So on the record in docket 112-00178, that is People of the State of Michigan versus Valenta Nance. Will the parties please introduce themselves for the record?
Jeff Roberts on behalf of the people, Your Honor.
All right, this is the time set for a order on application to set aside a misdemeanor marijuana conviction. This, because this was filed under the clean slate law, motion for application to set aside conviction is scheduled. This does not require an MSP criminal history report, proof of service, or attorney general's opinion for motion to be held. Prosecutor has 60 days from date of filing to object. If no objection, court may grant motion on 61st day filing under Michigan clean slate law. No personal appearance is required from any party if prosecutor does not object to the application and the applicant is pro per. It's my understanding, Mr. Brodowitz, that the people do not have an objection to the application to set aside. Is that correct?
At this time, Your Honor, I would like to put on the record that I do not believe, after looking at our file, that the people have received a copy of this motion to allow us to object. However, I guess that would be an accurate statement, being as the people did not file an objection in this matter because, again, as I stated, I don't believe the people ever received a copy of it.
Right. Yeah. And here's some question whether it does not require MSP criminal history report, proof of service, or attorney general's opinion. Prosecutor has 60 days from date of filing, and you're indicating that you got no notice of filing.
I looked in our file, Your Honor, and I did not see any motion to set aside. We have a docket entry in our system for this motion, but there is no actual motion in our file.
All right. But I have an indication that it doesn't talk about any notice to be provided, only that you understand that there's a hearing's been set. But I'm not certain because this clean application slate law is new. With that understanding, you don't have an objection to this, either did the attorney general, obviously. And I don't find anything that would indicate that there would be a violation. So I'm gonna, the hearing was held on June 6th. And my understanding is that because of the nature of the offense, this would set up, as it's your understanding, for the motion to set aside. Is that correct? I'm uncertain about. So I'm gonna indicate number 5 and number 7. The application is granted, controlled substance of possession of marijuana being the underlying offense. I'm not certain about the notice portion of this, Mr. Brodowitz, but you've indicated for the record that you did not receive notice, but you still don't have an objection.
Without seeing the motion, Your Honor, I'd be unable to make them.
All right. All right, I have signed the order indicating I'm not certain about indicating the application to set aside the marijuana conviction. No, I can't explain that the lack thereof notice since the AG got notice. I have a register of actions on the prior from that. This is a pro per client. But I believe that the client has met everything under the clean slate law. So for that, I've signed the order and we'll go from there. Anything else for the record in docket 12, so 12-00178, Mr. Brodowitz?
Nothing from the people, Your Honor.
Thank you. And then we have Mrs. Strowski. Do we still have Alfred out? That's Mr. Etheridge's case.
Yeah, but I guess he's not here. I was gonna update the form.
Oh.
I don't know if you want me to do that now.
Yeah, we'll call it after this one. So we're on the record in docket 23-01396. That's People of the State of Michigan versus Valerie Ostrowski. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Jackie Mossford on behalf of Ms. Ostrowski, who's standing to my right.
And ma'am, you are Valerie Ostrowski?
Yes.
Okay, this is the time set for a pretrial in the matter on a misdemeanor file. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor. After conversations with the defense, I believe there has been an agreement that has been reached in this matter. And that would be for Ms. Ostrowski to pay restitution on this file. And that restitution would be paid on her other misdemeanor file, which is set for sentencing before this court on Friday. And then upon sentencing and agreement to pay restitution, the people would then dismiss this file.
So did you want to move this file just to Friday for the sentencing?
I mean, if that's cleaner for the court.
So we can put all the files together?
I think we can do that. I think that's clear.
Rather than the kind of piecemeal the files, if we put them all for Friday sentencing, then we can do it all at once. And it just seems, I think that would be probably more protection for Mrs. Ostrowski and for the victims in the case if we do it all at once, with the understanding that there's no contact orders in place.
That makes sense to me, Your Honor.
Yeah,
okay.
That works with people.
All right. So what is that set for Friday?
Friday at 1:30.
So I'm going to indicate. So this is restitution to be paid and resolve case, and we'll set it for the sentencing date, the same date of, what is Friday, the 9th?
Do you want to set for restitution?
Just reset it, just reset. Yeah, just reset it for pretrial at 1:30. All right. So everybody will be back here on June 9th at 1:30, and we'll just make this part of the sentencing and wrap it all in, okay? So anything concerning moving this to June 9th, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Moss?
Briefly, Your Honor, I agree with the agreement that was placed on the record by Brother Counsel. However, in terms of the amount of restitution, we are still trying to reach an agreement as to that. The prosecutor's office has provided us with some receipts. Those receipts, however, are the items in question, door locks, have been upgraded to smart locks. So the cost of the receipts is not reflective of the alleged damage that occurred. So we're trying to reach an agreement to the actual.
All right. So this is so I can give you twofold on that, just my thinking on that. If there's some determination that this file is going to be dismissed on, then we will look at that to set a restitution hearing. But it's a fair market value. It's not the cost of replacement. So if they've upgraded, we're just looking at we're just looking at the fair market value of putting in the locks, not what the value that they replaced it with, which I think is probably a valid concern if you look at the law on this. So with that understanding, I'll let the parties talk to one another, and we'll revisit the issue on the 9th.
Thank you, Your Honor.
All right. Anything else for the record, docket 23-01396, Mr. Brodowitz?
Nothing from the people.
Mr. Moss?
Nothing further, Your Honor.
All right, you're all set.
Thank you. Have a good day.
You too. What's that? Oh, Miss Robinson, let's do this. And we don't know where Mr. Alfred is, right?
No, usually he appears over Zoom. He lives in Georgia, so.
Right.
I'm not sure. I'll reach out to him after the court.
All right. I kind of remember. And when I look,
He's not my client, so I'm,
right.
it slipped my mind, but I can reach out to him.
Well, I understand that I understand that he is in Georgia. This was a Zoom thing.
Yeah.
And so I don't have a problem with adjourning and not,
Okay.
it just provides a little different.
Sure.
'Cause
We can go on the record, though. I do want to
Right.
kind of put some stuff on the record in
Right.
regards to what's been going on with getting records and everything.
Right. Because it's really Zoom reporting, suspend, that the recommendation is nothing that, but I want to make sure it's just it's an out of state probation case essentially. All right, so we're back. We're on the record in docket 22-03552. People of the state of Michigan versus Larry Dawson Alfred. Will the parties please introduce themselves for the record?
Jeff Bradowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Alford.
And this is the time set for a sentencing on the matter. I will indicate for the record that Mr. Alfred is out of state. The court's aware he's out of state. This was essentially a probationary status by Zoom. Because of the nature of the out-of-state probation and the resentencing of concerning this matter, I don't have an objection, or I personally, the court doesn't have a problem with adjourning the matter just so we line up all the ducks concerning this matter. With that understanding, I know some things want to be placed on the record. Mr. Brodowitz, did you want to place anything on the record concerning this case?
Nothing from the people, Your Honor.
All right. Ms. Robinson?
Yes, just briefly. So this case was on for sentencing like a month or so ago. I requested some records. We were checking to see if he qualified for 7411 status. The probation did a review, said that he didn't qualify for some 2005 and 2007 convictions out of this district court. So I did request those records. They have come back, and the only thing that I've received is a 2007 home invasion that was dismissed. I don't have anything else. So I guess at this point, I would ask to maybe see what would be in probation's file. Obviously, we can't make that part of the court file, but we can do it in chambers or, however that needs to be done to see, where these convictions are coming from. And if maybe there's just a discrepancy somewhere.
Right. So, yeah, I don't have a problem with that. We can reset the sentencing. We'll have the person who prepared the probation report at least available so we can see what they base their
Sure.
claims on. If YT is available, he certainly would be available.
It's 7411, but yeah.
7411, okay. So with that understanding, we'll reset the sentencing for let's do 2 weeks. Just to make sure. There's no hurry on this, except that we want to make sure he gets notice. July 25th, that should provide plenty of notice.
Yep.
What time?
Let's do 1:30, please.
Okay. And then so our last known, he'll get notice at the 1502 Settlers Walk Lane, Marietta, Georgia address. That's the one you have?
That's the address.
All right. All right. Anything else for the record, Mr. Brodowitz?
Nothing from the people, Your Honor.
Anything else, Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. You're all set.
Yeah, would you be amenable to a meeting in chambers this afternoon before 1:30 hearings?
Yes.
Thank you. I think I'm specifically looking at Miss Decker and the old classic Miss Duke.
Miss Decker and Miss Duke.
Yeah. Miss Duke. Don't start with me, Wendy.
Do I need to
Don't-
wrangle a probation officer for that meeting?
Hey, Mr. Gaskin,
Yes.
how you doing, Duval?
Okay.
And Nathaniel, can I get a breakout room?
All right, ma'am, on Shanna's iPhone, you are Shanna Castillo.
Yes, sir.
All right. All right, this is the time set for arraignment on a probation violation arraignment. And I'm going to walk you through the allegations that have been made against you concerning your probation. And then we're going to talk about some of the options you have in regards to getting represented in this matter and setting it for hearing. All right, ma'am? Miss, and you'll have to take yourself off of mute, Miss Castillo.
Sorry. Yes.
All right,
Yes, sir.
that's all right. So I have violations that read the following. In a request and summons for probation violation from Jody Bayless, dated May 23rd, 2023, that the allegation is you violated your probation in a technical fashion by failing to refrain from a controlled substance. You had a positive test for amphetamine and methamphetamine. That's the first violation, and it's listed as 13, but that's the first one. You also had positive violations on May 5th, on May 12th, May 10th, May 5th. And you failed to submit to testing on May 11th. Do you understand the nature of the allegations that have been brought against you concerning your violation of probation?
Yes, sir. I do understand.
All right. And so you have the right to counsel in this matter. You, of course, it's not the same counsel as when you had counsel for the underlying offense. And so, and I would suggest it's probably a good idea if you had the public defender's office previously represent you, that you do so in this regard too. You, in this file under the underlying offense that you were placed on probation for, the property case, you had the public defender's office. Do you plan to seek representation from the public defender's office in this case?
Yes, sir.
And I think that would be a good idea, ma'am. So what I'm going to do is I'm going to set this for a hearing, a probation violation hearing, and I will give you contact information to make application. You're going to have to make application to the public defender's office, and I will give you that information, and I would set that as a priority, okay? Because we're going to set it within 2 weeks, and I want to make sure that you have representation at that hearing on these multiple issues. So let me give you the number to the public defender's office. It's 517.
Okay, I'm ready.
Okay, 517-679-2979.
Okay.
All right. And so I would call them immediately. I would give them this date for formal hearing on the probation violation hearing. And the date is?
June 27th at 1 o'clock.
June 27th at 1 o'clock.
Okay.
So indicate to them the date and time of that probation violation hearing and make application so that you have representation for that hearing because of the nature of the allegations and that you've had them before. I think it's a good idea. All right, Ms. Castillo?
Yes, sir.
Okay. You're on Zoom. There's an indication here that you are seeking, that you have sought residential treatment. Where is that in the mix right now?
That was previous, and that was with Clearview at Sacred Heart.
All right. And is that still an option at this point in time?
It is an option, because I've been there before. However,
but you wouldn't be
there's
the first person to go through multiple residential treatment.
Right. I guess what I mean is their admissions are backed up. However, because I've been there before, they kind of moved me up in the
All right. Well, I would think it would be a good idea. I'm telling you that it would be a good idea for you to have something set up in regards to treatment on this file, but you can talk to your lawyer about that. All right, ma'am?
Okay.
All right. I will see you on the 27th at 1 o'clock. All right, ma'am?
All right. Thank you.
Thank you.
Oh, fuck. Oh.
All right, Mr. Feigelson, are you ready on Mr. Gaskin?
Yes, Your Honor, I am. Thank you. Good afternoon.
All
Your
right.
Honor.
Good afternoon. So we're on the record in docket 21-02461. That's people, the state of Michigan versus Duval Gaskin. Will the parties please introduce themselves for the record?
Yes, Your
Jeff
Honor. Good
Brodowitz on
afternoon.
behalf of the people, Your Honor.
Go ahead, Mr. Feigelson.
Sorry about that, Your Honor. Good afternoon, Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Gaskin this afternoon, Your Honor.
And sir, you are Duval Gaskin?
Yes, Your Honor.
All right. You can hear me all right, Mr. Gaskin?
Yes, Your Honor.
All right. This is the time set for a sentencing today. Mr. Brodowitz, do we have any restitution in the matter?
I do not believe so, Your Honor.
All right.
I would also just like to mention, I don't believe I received the PSI for this case.
I have that Mr. Gaskin contacted probation office on November 17, 2021. Defendant was advised to appear due to the quick reset of PSI, nor assessment could not be completed.
Okay.
But it appears then that Mr. Gaskin was also was on. He must have been on bench warrant status. Is that correct, Mr. Feigelson?
I believe so, Your Honor. This is a case from 2021, Your Honor.
All right. Mr. Feigelson, you've had the opportunity to speak with Mr. Gaskin.
I have, Your Honor.
All right. Any allocution concerning this matter?
Yes, Your Honor. I've had a chance to speak to Mr. Gaskin. I don't know if the court's aware, but I know he has two pending felony matters. One, I believe, is presently in front of your court. The other was in front of your court, and I believe is now up in the, or not up, but in the circuit court, Your Honor. So I want the court to be aware of that. This case is a 2-year-old attempted RNO and assault and battery case, Your Honor. He has about 62 days of jail credit, Your Honor. I'd ask for one of two things today. I'd either ask for a jail credit for the 62 days and give him the 62 days credit. He's going to be bond, felony bond in front of one of the circuit court judges here. So he's going to be on some sort of monitoring system anyway, or he wishes to be placed on probation, Your Honor. I'll leave either one of those two up to the court and we can go from there. Thank you.
All right. Thank you. Mr. Gaskin, is there anything you'd like to say to the court before the court passes the sentence?
Yes, I did not fail to appear to my court date. It was supposed to be over Zoom, but I forget what the judge's name was. She told me to come in. At the time, I was in Detroit, and when she told me to come in, it was over Zoom. I told her it was a possibility that I could make it. So we had that understanding, but I did not like mean to miss my court date, or it wasn't like I just skipped it. It was over Zoom, and then she said, come in the office, come in the courtroom the next day, and I was in a different city.
All right. Well, sometime after that, we lost track of you between November 23rd of 2021 and April 7th of 2023. So we lost track of you someplace there.
Yes.
All right. Anything, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right.
The court's discretion.
Well, the sentence. I don't believe that Mr. Gaskin is a good candidate for district court probation. This is for count 2 of guilty plea on attempted RNO, which is a 1 year, and an A and B, which is a 90-day. It's my understanding from the attorney that there is credit for. Did you say 42 days, Mr. Feigelson?
62 days, Your Honor.
62 days. So the court will sentence Mr. Duval to 92 days in jail for credit for 62 days previously served. So he has remaining 30 days. There's fines and costs to the level of $125. That's $75 crime victims' rights fee. State minimum cost be of $50. There's also a statement of Mkoski of $50 on the second charge for a grand total of $175. It's my understanding that the defendant has other files going on, so I'll administratively close those files. And so credit for 62 days, spend an additional 30 days in jail, which is 92 days in jail. That's the sentence of the court. No probation in this matter. Anything else for the record, Mr. Feigelson, on docket 21-02461?
No, Your Honor, thank you for your time today.
All right, thank you. You're all set, Mr. Duval.
Thanks, Judge. Have a good day. Take care, Mr. Gaskin.
You too.
Thank you.
Yeah, that was it for me. Thank you so much.
I'm ready, Mr. Nemeth. Whenever you are.
All right, Mr. Nemeth. Just making sure I've got the case. Right, we're on the record in docket 22-03260. That is people of the state of Michigan versus Alex Nemeth. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Nemeth.
And, sir, you are Alex Nemeth? All right, thank you. This is the time set for a sentence. Mr. Brodowitz, just looking at this, is there any restitution off the top?
There is not, Your Honor.
All right, thank you. Ms. Robinson, have you had the opportunity to go over the pre-sentence report with your client?
I have.
Any additions, deletions, or corrections?
Not at this time.
Allocution, Ms. Robinson.
Yes, Your Honor. We would ask the court to follow the recommendation of the probation department with the understanding that he is currently on probation on out in 55th for the same amount of time and technically the same terms. He is doing well. He's actually still going to CMH and still following up and doing everything with them. He sees them 3 times a week. And I did provide the court with letters from his caseworker and therapist about how well he's doing with their programming. He's currently living on his own with a roommate now in CMH supervised housing and seems to be in a really good spot. He's got family support. His father's here with him today. And I do think that he would be a good candidate for probation. So I would ask the court to simply follow the recommendations. I think, I don't, is there, so it looks like he is also getting testing. He's getting testing through his 55th probation. So I guess maybe if we could not order the testing here as well, to make sure they don't overlap. Like I'm fine with must report to 55th probation testing policies, or I just don't want him to have to test twice because finances are an issue. So
right, and it does. I understand that, and also and it doesn't do any good if both agencies are being paid. So, thank you. Any comment, Mr. Nemeth, before the court passes sentence?
No, thank you.
All right. Anything from the people, Mr. Brodowitz?
The people would just leave it to the court's discretion.
All right. This is an assault and battery, count 1, guilty plea. That I'm sentencing you on. I will follow the judgment of sentence to commitment to jail. We'll talk about the testing because you're on different probation, but I must say that your progress in this regard is noted, okay? Whatever you're doing, you need to keep doing, okay? So I'm gonna suspend 93 days in jail beginning June 6, 2023. There's 0 credit given, but I am going to suspend the amount of time all on the successful completion of probation, which essentially means for the 12 months, you kind of have to answer probation and me. But as long as you're doing what you're supposed to be doing, which you are, that's what everybody says, that this shouldn't be a problem, okay? So yeah, so I'm gonna set fines and costs. Fines at $200, costs at $200.
Your Honor, would you actually consider maybe waiving the fines and the obviously not the mandatory ones, but the other ones?
Right.
In this case, just because he's not working, he's focused on treatment 100% at this point.
Well, and I will consider waiving it only because I've been thinking about this random PBT look at, and so I'll waive fines and costs in this matter. Crime victims' rights fee $75 is not waivable. State minimum course cut of $50 is not waivable. Probation $360 is $30 per month. I'm going to put you on probation for 12 months, which is a pretty long time, but it looks like probation is doing you well right now. Okay. No contact with the victim, Sierra Reuter, 2,000 feet. I don't know if that's an issue or not, but we're just going to keep it along. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. So I'm going to have you at this time submit to random PBTs in your analysis, but that can be revisited. If we're just duplicating what's already been done, there's no reason why financially you should share that burden. Okay, so we'll keep it in place now, but once probation gets their orders in place, there's no reason why they can't share that information, and we can save you some money in that regard. So that's the plan right now. Okay, no bars or nightclubs. I am going to put you in the anger management group. All right, I think that's important. I think that goes along with other things that we can assist. While you have us, you should take advantage of our options. Right, these are all options that can work for you. And so they're not helpful to everyone, but you can find things that'll work for you. Okay. Continue your mental health services with CMH, which you've done. All right. And then it's on all my orders, do not purchase or possess firearms, ammunition, or weapons of any kind. With that understanding, this is all a plan for success for you. Okay. There's nothing in here that's stick motivated. It's all carrot motivated, so to speak. So the best thing is for us not to meet, right? If you come back, you start taking away options, and then I'm left with the only ability to do the one option I don't want to do, which is to use the suspended 93 days, which I don't want to do. Okay. Some people might look at that as a stick. I don't, because it's not an option to me. I'd much rather just have you continue what you're doing. All right. All right. So with that understanding, I'll sign the judgment of sentence, which is the updated math on that. And Mr. Nemeth, you should be all set. Okay, sir. Thank you. Yeah,
Oh, actually, Your Honor, if I could maybe just note
Sure.
one more thing. So it looks like the victim, I forgot to mention, she is a employee of Sparrow Hospital. So he has no memory of the incident.
Right.
Has no idea who she is. So obviously, if he needs to get treatment, I just, told him that he can go there, just obviously.
Well, if he needs treatment at Sparrow, just make them aware that he's got to be 2,000 feet from her pursuant to the order. But I don't look at that as a typical issue in this case. I mean,
Sure, I didn't think so either,
Right.
but I just wanted to put that out there that if he has to go to the ER and she happens to be like the nurse
Right.
that day or something,
right.
with a life-threatening
Fair
issue.
enough. I don't know if
He should
either
go
one
to
of
the ER.
I don't know if either one of them would remember one another,
Sure.
but I do think I do think that we cover it. Okay, so JOS is followed. Anything else from the people, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right, Ms. Robinson, you're all set?
Yes, I am. Thank you.
All right, thank you. Good luck to you, Mr. Nemeth. I would go down to the 5th floor and just check in, okay?
Okay.
All
Thank
right.
you.
Yes.
Oh, you just highlight for him?
Yeah. I wrote it in clerk language. How's that?
Perfect. Write this one in clerk language too. Because I say JOS, CJOS.
Oh, that's probation. So I agree with that.
That's Mr. Nemeth. Pay and fee of $30 per month. 769-4A is granted per the recommendation. There's to be no contact with the victim, Monty Nason, within 2,000 feet of the victim. Lives, works, goes to school without consent of the court. Recognize, I'm gonna hold you to that, direct or indirect, okay? Yeah, that's for 6 months, those are the rules. After 6 months, you play by different rules, okay? No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs or analysis as directed and pay any fees. No bars or nightclubs. I'm going to strike the cognitive behavioral therapy as not being a part of the Killebrew as I see it. Okay, that seems to be extra from the Killebrew that was recognized. So I'll strike that. Obtain and maintain employment has not been a problem in this case, and not purchase or possess firearms, ammunition, or weapons of any kind over the term of probation for the next 6 months. Mr. Gissendanner, you're not a kid, and I'm not going to treat you like a kid. All right. I think the most thing you can do here is to follow your judgment of sentence and then put this behind you. All right. I think you want to do this more than anybody else at this point in time. With that understanding, are there any questions concerning the sentence of the court, Ms. Smith?
No, there are not, Your Honor. Thank you.
Mr. Easterly?
Not for the defense judge.
All right, thank you. That's all for the court. I'll sign the new judgment of sentence and you should be all set. I'd go down and check with probation just to know that you've come in, you've checked with them. They'll have that file ready, and then you can go from there. All right, sir? All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
I did not. Yeah, it wasn't part of the Killebrew, and I didn't want to.
I'm ready on Mr. Miller whenever the court's ready.
Okay. Let me get the new sentence. Well, now I'm a creature of habit. It's all pretty. Okay. Said Mr. Miller?
Yes, Judge, she's the one in custody.
I don't know if we meet Mr. Brodowitz for this one, do we?
Probably not.
Well,
I mean, it was a simple drunken disorderly,
Yeah.
so.
it looks like times.
And
It
he's
looks
got
like
like
time
70 some
served.
days
Yeah.
in, so that's all I'm asking for.
All right. All right. So we're on the record in docket 22-02920. That's people of the state of Michigan versus Michael Allen Miller. Will the parties please introduce themselves for the record?
Aaron Robinson, Mr. Defender for Mr. Miller.
All right. And
Okay.
sir, you are Michael Allen Miller?
Yes, sir. Sorry about that. I got ahead of myself.
That's all right. And you can hear me all right, Mr. Miller? All right, this is the time set for a sentencing. I do not see any restitution ordered in the file. So I'll indicate for the record, there's nothing that would indicate from the probation department that restitution was to be ordered in the file. Ms. Robinson, you've had the opportunity to go through the pre-sentence report with your client.
I have,
Any additions, deletions, or corrections?
not at this time, Your Honor.
Allocution.
Yes, Your Honor, we would ask for the court to sentence Mr. Miller to time served. It looks like this case is, he's been in custody for about 76 days at this point. He pled to a drunken disorderly person charge. He's got some conditions he wants to get out. On the outside, get back into getting those treated, as well as just getting back and trying to get his life together. And so I think 76 days is probably sufficient for a charge like this, and we simply ask for time served.
Thank you. Mr. Miller, is there anything you'd like to say to the court before the court passes the sentence?
Man, I got, how much time do you have? I mean, I'm being really honest. I've been going to CATS in here. I plan on continuing CATS when I get out because I do have issues I need to work out. I plan on hitting the first A. I'm done drinking. I've been homeless for quite a while now. I have some goals, some small term goals, working up to big term goals, because I'm not trying to bite off more than what I can chew. If I can get out today, I know first initially I'll have to go stay at the city rescue mission, and they do not allow drinking there, so I will not be able to drink, because if I do, then I will be like literally on the streets with nowhere to stay. I need to get out and get a job. Hopefully I have my social securities still, because when I came in here, I had to appeal it because I missed my 3-year evaluation, and I've had it since I was 5 years old. I just have so many goals, and I gotta get my life.
All right, well, I certainly like what you're saying in regards to continuing treatment and having options that are more available than this. So I'm going to follow the judgment of the sentencer. It is ordered that you spend 76 days in jail beginning June 6th for credit. How many credit is 76 days previously served? Yeah. I'm going to waive fines and costs in this matter. This is for drunken disorderly. The crime victim's rights fee of $75, state minimum cost of $50 for a total of $125, and that will be administratively closed. Let me see. And so Mr. Miller, you're essentially time served, and any fines and costs have been administratively closed. So you should be all set to start something new, okay?
Excuse me, sir. One question. So I have nothing pending, and I am getting out today.
I don't know. I don't know what else you've got going on, but on this file, you're all set. On this file, your time is served.
Okay.
This isn't gonna hold you in anymore, okay,
so
Mr. Miller?
This file won't hold you in anymore.
Say that one more time, ma'am.
This file isn't holding you in anymore, okay?
And so, depending on how do I find out if I got any other things going on?
Well, they'll be able to tell you if you have any other holds. I don't see anything in my system, but I mean, my system's not always up to date, and I only have access to what's in this county,
Okay.
so.
But as far as this file, you won't have any hold on you.
All right, thank you.
All right. Take it back to JOS.
Ms. Robinson.
Ms. Robinson, you want to grab that judgment?
Oh, yes.
Thank you, I'm sorry.
I forget, but it's a brand new one and now I'm a creature of habit. All right, judgment of sentence is signed. And the ACMC is all set. All right, Mr. Miller, you're all set. Thank you for your appearance today.
Yeah, thank you, sir. Sorry, out my ass, I just didn't know if you heard me or not. I'm sorry. Thank you. You guys
All
have a
right,
good day.
you're fine. Mr. Abbott, are you ready to go?
Yes, Your Honor.
That is on
Tyrese Wyndham.
Mr. Wyndham. Okay. So are we setting this for a restitution? No, that's Mr. Hernandez. I'm at the wrong file there. No, I pulled an extra file.
You're in that
All right, so we're on the record in docket 22-03408. That's People of the State of Michigan versus Tyrese Wyndham. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott with the Public Defender's Office representing Mr. Wyndham. He's standing to my right.
And sir, you are Tyrese Montrell Wyndham?
Yes, sir.
Okay. This is the time set for a sentence today. Is there any restitution, Mr. Brodowitz?
Just 1 second, Your Honor.
I do have a restitution form in the amount of $11,607.67.
Yes, that is.
And is that to Lowe's?
Yes.
Yes, Your
That's to
Honor.
Lowe's Company Incorporated? Okay. So I want to make that a part of, that's not a part of this. Or at least I want to write it in there for myself. All right. Have you had the opportunity to go through the pre-sentence report with your client, Mr. Abbott?
Yes, Your Honor.
Any additions, deletions, or corrections?
No.
Allocution, Mr. Abbott.
Thank you, Your Honor. Mr. Wyndham continues to be employed. He's working at General Motors, making a good income. He understands the debt that he owes and the wrongfulness of his actions and accumulating that debt. And he's determined to make payments and cover that restitution as soon as possible. I asked the court to grant HYTA. It's my understanding there's no objection, at least during their plea bargaining phase, there was no objection from the people on HYTA. But one of the elements of the terms of probation is no drinking or using marijuana and participating in PBTs. It seems like an unnecessary set of conditions, Your Honor, since there's no allegation of alcohol or drug abuse or any kind of substance abuse situation here. So I asked the court to consider removing those conditions. Other than that, I'm confident that he can succeed at probation and get back on track. Thank you.
Thank you. Mr. Brodowitz, any comment on the sentencing concerning Mr. Wyndham today?
Just briefly, Your Honor, I would say that Mr. F was correct. There was no objection from the people as to HYTA status, and there is still no objection from the people to HYTA status. Other than that, the people would leave it to the court's discretion.
All right, Mr. Wyndham, is there anything you'd like to say to the court before the court passes the sentence? All right, thank you. This is in regards to a guilty plea on an embezzlement, 200 to 1,000. So this is what I'm going to do. The credit is given for 2 days previously served. I am going to follow the recommendation. There's 6 months probation. All right. I'm going to suspend 28 days. Okay. So I'm going to suspend 28 days on your successful completion of probation. So there's no additional jail time. But what I've done is it's essentially a stick saying complete probation, okay? You have an enormous amount of money to pay. So we're gonna tailor this to fit your financial goals. You have a good job. We want you to keep your job. We want you to be responsible and pay back your debt. And you're a young man, so we want this not to hang over your head, okay? So take use of these options as we give it to you, all right? Hopefully you've learned from this, and this is the last time that we have to go through this, okay? So I'm gonna order fines and costs in the $200 to $200 fines and costs. Crime victims' rights fee is not negotiable. 75, state minimum cost 50. There's restitution and there is probation. So 6 months. So I'm gonna add that up so you know what you're looking at. The main thing to do here is to start paying towards this debt. Because that shows the priority you've placed on it. All right. It's not an answer because that's not an answer, but it's an answer to how you're dealing with adversity now that we've gone through this, and you don't want, you don't want to meet with me on a Tuesday afternoon again. So let's just avoid that from now on. Okay. And mostly on a misdemeanor charge. All right. So with that understanding, we're going to put it's $400 plus $75 crime victims' rights fee, $50 state minimum court costs. There's a restitution of $11,000 plus $180 for probation. So you've got a grand total of $12,312. That is not a light sum, okay? So, but you've got a good job and you want to give this priority. You can pay that over terms of your probation, but the real gift here is YTA. Okay. If you get through the next 6 months of probation, you're granted YTA, which means you really get a fresh start from this. All right. So you don't want to mess that up. Okay. You don't want me to revoke YTA. I agree with Mr. Abbott. I didn't see anything that would indicate that you should bear financial responsibility for PBTs and for possession of alcohol. All right. Recognize though that that's not the main theory here. Where the main theory is you've got a lot of money to pay back, and so you should work on that, right? So I'm not ordering use of possession of alcohol, marijuana, controlled substance without a prescription. That's not a part of my sentence today. I'm not having you submit to random PBTs or urinalysis. I just don't see it as a part of this case, in that it would be a financial burden, and you're financially burdened enough, okay? You're not to return to Lowe's stores during the term of probation. That's 6 months, okay? And
correct.
What's that?
All Lowe's stores.
That's all the Lowe's stores. I would just keep them all off your radar. Go to Home Depot, okay? Don't go to Lowe's, all right? Not that I prefer one or the other, but for your purposes, for 6 months, that's a preference, okay? I am gonna order the moral recognition therapy, okay, as part of your programming, and you can discuss that with your probation officer. I think that's I don't have any. I'm not going to order anything else, just because your priority is making restitution in this matter. Okay. Anything else for the record, or any comment on the sentence, Mr. Abbott?
No, thank you.
All right. All right, I'll sign the judgment of sentence. Mr. Wyndham, you should go down to probation and check with them. Just let them know that you've gone through the sentencing. You're there to check with them, to check in and get this process started, okay? All right, anything else for the record? Docket 22-03-408, Mr. Brodowitz.
Nothing from the people.
Mr. Abbott, you're all set?
We're all set.
All right, Mr. Wyndham, good luck to you, okay? Who's Samsung?
I guess it's but I sent him a chat, didn't respond.
On the On the Samsung, sir, what's your name?
Mine?
No, Mr. Wilson, I've got your name up.
Okay, thank you.
Are you Mr. Wilson?
I am.
All right. I don't know who's on the Samsung there. Sir, on the Samsung? Two? That's it? Oh, thank you. Ma'am, under the moniker of Fox Development, can you identify yourself? That's you, ma'am? And you're on mute? Yeah. What's your name?
I'm sorry, this is my son's tablet and my phone is broke and this is Android tablet, so it's working real slow. And it's
All right, what's your name, ma'am?
Angel Crockett.
Angel Crockett. All right.
I think she may have been a victim. I missed her.
No, she's at 2 o'clock.
Okay, I'm sorry.
All right. And then,
She's supposed to be in person.
I don't think this stupid's here.
She left. She was here, but she left. She showed up with her kids, with nobody else. Well, she knows she was. I'm hoping that by the time we're done with everything else, she can. Because.
All right. I don't know. That's Mr. Wilhart. Are you there? Mr. Wilhart? You want to unmute yourself?
Yeah, I'm here.
All right. Mr. Wilhart, I hate to wake you up in the middle of your court date, but we need to arraign you.
Okay.
All right. You're not doing yourself any favor by sleeping and not being able to wake up during your arraignment. Do you understand that?
Yeah, I'm up.
Okay. Well, I'm not responsible for you, but it just seems like a poor time to take a nap. All right. So we're on the record in docket 21-02793. That is People versus Cecil Wilhart. And sir, you are Cecil Andrew Wilhart. Is that correct? Is that correct, sir? You are Cecil Wilhart?
Yes, sir.
All right. So it's docket 21-02793. This is the time set for a probation violation arraignment. And I'm going to indicate to you the nature of the violations that are alleged against you. And then we're going to talk about some of your options and set this for formal hearing. It is alleged by probation officer Jody Bayless on May 23rd that you were in violation of your probation in a technical form by failing to pay fines and costs for the balance of $505. Last payment was made February of 2023. That you failed to refrain from alcohol per AbraHealth on May 15th, positive for alcohol. Per results from AbraHealth in your second violation. So those are the two violations. Those are the last two I have of indications that you violated your probation. I also have April 13th violate that you've admitted to. So these are new ones. These are all May 23rd violations. You've been through this before, but I'll talk to you about this. You know, you have the right to counsel concerning this violation and setting this for hearing. I would recommend that you seek counsel from the public defender's office in this case. Do you plan to seek a representation from the public defender's office?
Yes.
All right. And do you have that number that they can be contacted at?
Yeah, can you please give it to me again?
Yeah, the number is 517-679-2979. That's 517-679-2979.
Okay.
Indicate to them that you're seeking public defender representation on a probation violation. And the probation violation hearing is set for
June 27th at 1 o'clock.
And it's set for June 27th at 1 o'clock. So tell them when you call them that you would like representation for June 27th at 1 o'clock at the number that I've given you. All right, sir?
Okay.
All right. So do you have any questions of me?
Yes. You said how many violations I got?
On the current violation, I say you have two. You have a testing positive for alcohol and a fail to pay fines and costs.
All right.
All right. So I will see you on June 27th at 1 o'clock. All right, sir?
So this, so you want me to come in person next time?
Yeah, definitely come in person.
Okay.
All right. We'll see you on the June 27th date, and you should make calling the public defender's office a priority. All right, sir?
Okay.
All right. That's all for the record docket 2102-793. You're free to leave the Zoom courtroom, Mr. Wilhart.
All right. Thank you.
You're welcome. So which one?
I'm already on Mr. LaPaw.
On Mr. LaPaw.
Yeah.
Do you have Miss Crockett?
I don't. Oh, I do have Miss Crockett, but I don't have her here. That's what
She's on Zoom.
Oh, she's on. Oh, okay, great.
She said she has Fox Development. But
Okay, I will talk to her,
All right.
but we can do him real quick.
let's do LaPaw. All right, we're on the record in docket 23-01014. That's people of the state of Michigan versus Kenneth LaPaw. Will the parties please introduce themselves for the record?
Jeff Radowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. LaPaw.
And sir, you are Kenneth LaPaw? All right. This is the time set for a sentence in this matter. Mr. Brodowitz, is there any restitution on this file?
I do not believe so.
All right. Ms. Robinson, have you had the opportunity to go through the pre-sentence report with your client?
I have,
Any additions, deletions, or corrections?
not at this time.
All right. Allocution.
Yes, Your Honor, we would ask the court to follow the recommendation of the pre-sentence investigation report. However, maybe considering a term of 9 months instead of 12. Mr. LaPaw has been doing well in this case, and he's still been working. He works as a painter. He's also doing well as far as staying clean and staying sober. Basically keeping his life together. He realizes like what happened at this time was a mistake and it was really just a one-time thing. He is willing to take accountability for those actions and complete the required terms of probation and anything that comes with that. But otherwise he is doing well. I would ask instead of with the no contact order for that to be or allow for third-party contact for like things such as child visitation and things like that, because they do have children in common.
All right. Mr. Brodowitz, have you heard from Ms. LaPaw concerning the no contact order?
I have not, Your Honor.
All right. All right. Mr. LaPaw, is there anything you'd like to say to the court before the court passes sentence?
The only thing I was concerned about with it was being on my record, because the previous lawyer said that I qualified, and I got in a confrontation when I was like 16 or 17. So it was like, I'll be 48 Saturday, like 30 years ago, 30 something. Besides that, no.
Yeah, I don't know what happened on the prior assault, but it's what kept you from 769 4A status.
Okay.
Yeah. That being said, you're not a kid, so I'm not going to treat you like a kid.
Yeah,
all right?
yeah, I know.
Yeah, I mean, it goes that goes a long way also with the court, considering what options we have today. All right.
Okay.
So it's a finding of the court. This is a guilty plea to domestic violence. Going to follow the recommendation of the court and indicate of the judgment of sentence of probation. Spend 93 days in jail, credits given for 2 days previously served, suspend 91 days upon successful completion of probation. That's kind of the stick, right? You know, that it carries over your head. I'm going to set fines and costs at $200 fines, $200 costs, crime victims' rights fee of $75, state minimum cost fee of $50. I'm going to only put you on probation for 9 months. Okay. So we're going to knock off 3 months of that. So 270. All right, so I'll give you a grand total for that of, for the record, of $795. Probation's at 9 months. No contact with victim Lindsay LaPa. I'm gonna leave it for probation discretionary. I'm going to allow third-party contact if you need to arrange things right now. All right. So no direct contact with her, third-party contact through another person, as long as it's just arranging stuff. But if I hear anything different, like she's uncomfortable with that, we're going to remove that. Okay. But that's just a way for you, you know, you've been in a relationship and there are things that you need to have done. And so I will allow the third-party contact, but no direct contact. That being said, of course, there's no assaultive or threatening behavior. So even by third-party contact, if it's assaultive or threatening, it's going to be a violation. All right. Okay, no assaultive or threatening behavior, no use of possession of alcohol, marijuana, controlled substance without a prescription. Submit to random PBTs or urinalysis as directed. You should go through batter's intervention services and pay the fees for that. Obtain and maintaining employment shouldn't be a problem, and not possess any purchase or possess firearms over the course of this probation. Okay. With that, if you complete that and you're able to complete that, then you can just put this behind you. All right. Your record indicates that you're not somebody I'm going to worry about. This seems to be like a blip in the road, so to speak. That being said, it's a big time blip right now. Okay. You're on probation for 9 months. You could violate, and of course, your relationship with Ms. LaPa is drastically affected by this. But it's not anything that you can't overcome because you've been successful in the past. All right. Yeah. All right. Anything else, Ms. Robinson, on docket 23-01014?
No, Your Honor. Thank you.
All right, Mr. LaPa, good luck to you. You might want to check in with probation on your way out. Okay.
Okay, thank you.
All right. Thank you. Third-party contact. Yeah.
For probation violation, you can even use it. Okay. It's pretty.
All right. I was just looking
I
at.
wasn't sure what I heard. Yeah. It's doing that. So the Flores, just take that later down and start throwing it out. Yep.
I think they're very.
Otherwise, like. Okay, I'll remember. I'm kidding, you know, I told her they can't. Either that or. So she has to like move her vehicle somewhere else and she can.
The JOS goes in the old file, and this is the sentencing file, or they both? All right.
The only time I know which file it was, until they don't get probation. How's that for an answer?
I know.
Can I get a breakout room?
With Miss Crockett?
Yeah.
Okay. What are we doing on Ashley Hernandez?
I spoke briefly with Mr. Austin.
Oh, Mr. Austin's here on that one.
Yes, he's
Okay.
not in the
All right.
courtroom right now.
All right,
I believe
that's
he's still
fine.
waiting on his client, but I believe their
And then,
intention is to still run the restitution.
all right. And then on Hernandez, we have that file. We have.
Yes, I still have, at least for mine, Ms. Diamond, Ms. Duke, Mr. Miller, Ms. Crockett, Mr. Hernandez, and Ms. Hernandez.
Take care of Mr.
And we took care of Mr. Miller.
Okay.
Well, it was a disorderly, wasn't it? Yeah.
Yeah.
It was just a time served disorderly.
Okay. You remember how?
72 days.
Okay.
If I remember correctly, 76 days.
Hello.
Are you, Ms. Sutter?
Oh, I'm Peach.
Are you ready on any of these?
I have Ms. Diamond here with me.
All right. Mr. Brodowitz, are you ready on pretrial on Ms. Diamond?
Yes, sir.
All right. So we're on the record in docket 23-00473. That's People of the State of Michigan versus Sharon Diamond. This is a set for final pretrial today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, I have had some discussions with Ms. Sutter. The case continues to be, I guess, in negotiations. Ms. Sutter has presented me with a new potential resolution in this case, which I would need to discuss with the complaining victims in this matter. And so with that, the people, I guess we would usually ask that this be set for another court date, whether that's another final pretrial or a review, or however the court would want to set that.
Okay, we are at final pretrial, and I can set it for a second final pretrial if that's, if negotiations are continuing.
Yes, Your Honor, that would work for both sides, I believe.
All right.
Excuse us. Excuse us? Is this with Sharon Diamond? I can barely just hear you.
Yeah. That's the victim, Mr. Wilson.
Is that Mr. Wilson?
Yeah,
All
I
right.
think he's
Mr. Wilson, we placed you on mute. You should be able to hear us. This has been set for final pretrial, an adjourned final pretrial, so that negotiations can continue. Mr. Brodowitz, I'm assuming that you're going to have some contact.
Yes.
With Mr. Wilson.
Yes.
Yes. Can I approach this?
No, your responsibility is talk to the prosecutor in this case, sir.
Well, sir, we don't want a deal. We want her to be prosecuted, Your Honor.
All right. Well, that has nothing to do with me. That has to do with the prosecutor's office.
Okay,
I didn't
well,
bring the charges against
we've
Ms.
discussed
Diamond.
this
The
with
prosecutor's
prosecutor.
office brought the charges. All right. You can explain that to him, Mr. Brodowitz, okay? All right. So we'll set for final pretrial on.
Your Honor, we've got, can I see this again? I mean, I'm sorry, I'm being like this. I can barely just hear you, but,
Mr. Wilson.
Yes.
We're setting it for final pretrial. If you have any questions, you contact Mr. Brodowitz, the assistant prosecutor, or somebody in that office.
For a final pretrial?
But you don't speak to me, okay, sir?
Well, I'm asking this question. Why are we setting it to a final pretrial? We've been through 5 of them.
Because all right, we'll set it for jury trial. Let's set it for jury trial.
Your Honor.
27th of 8.
With a final pretrial.
Okay. Okay.
Good. So we'll set it for final pretrial and jury trial in this date. So you'll have your day in court, sir. The final pretrial is set for, what did we say for the final pretrial?
Well, here's my one. Since we switched your schedule for the jury, I don't really have any empty pretrial. So does it have to be in pretrial, final pretrial, or could it be late morning?
That I'm uncertain of.
Hold on, stop.
So, Mr. Wilson, we're getting you a jury trial date, okay?
Okay. Yeah, because we've had, that's the judge.
Well, we're gonna have a final pretrial too, but we're setting a jury trial date also.
Yeah, because Your Honor,
I don't believe so.
Mr. Wilson, this is what we do. We set it for final pretrial and then jury trial. All right. So just keep in contact with the prosecutor's office.
So in other words,
so the final pretrial is set for
June 27th at 1.
June 27th
Thank you, Wendy.
at 1 o'clock.
And the jury to file on June 18th, or I'm sorry, July 18th at 8.
July 18th at 8 o'clock. All right, so the following dates have been set on this case. Final pretrial is set for June 27th at 1 a.m. At 1 p.m., I should say. June 27th. Let's make things harder than they have to be, okay? June 27th at 1 p.m. And the jury trial is set for July 18th at 8 a.m. Anything else for the record, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Sutter?
Nothing further.
All right, Mr. Wilson, keep in contact with the attorney, Mr. Brodowitz. Ms. Diamond, keep in contact with your attorney, Ms. Sutter. We've set this for final pretrial June 27th at 1 o'clock and jury trial on July 18th at 8 a.m. Anything, that's all for the record, 23-00473.
Thank you.
Thank you.
Now, how's that for your justice system, Lenny? And that prosecutor's playing, just like I freaking told
You can remove them from the courtroom. Can't wait for that trial.
Nathaniel, they're on Zoom. Huh? They're on Zoom, right? I kicked them out. Okay.
Yeah, we had to put them out of the.
Okay.
So expect several phone calls.
Oh,
He already knew that. Thank
Yes,
you.
I am fully, I have, the voicemail pop up on the email. I fully expect to see a voicemail pop up in the next few minutes here.
Miss Crockett?
Yes, I'm ready on Ms.
Are you ready on Miss Crockett? And
I
then
am.
Mr. Austin, you're good on Ms. Hernandez, correct?
That is correct.
Okay.
You don't know. Oh, yep.
Ms. Crockett is joining us by Zoom.
Correct. I believe she was pre-approved for Zoom.
I think she was.
Out in Benton Harbor.
Yeah, she lives in Benton Harbor. That's. Even her fault then. Ma'am, you are Angel Crockett? Is that a yes, ma'am? I can't hear you. I'm sorry. I still
Her
can't.
microphone's really soft. Her phone's not working.
So you want to get as close to the microphone just so I can hear you say yes.
Yes.
Okay, good. I heard that. All right, this is the time set for a sentencing. Is there any restitution on this file, Mr.? I have amount to be determined on the restitution. Is that correct? Which would indicate that this should probably be set for restitution hearing.
That's correct. It looks like they requested $270. However, they have not provided proof of that. So we can set it for a hearing and
All
see
right.
if they come with proof.
All right, so I'm going to order 0 restitution at this time, and we'll set it for set it for hearing.
I guess maybe the probation officer can let them know.
Right.
If it needs to be a hearing.
All right. With that understanding, have you had the opportunity to speak with Ms. Crockett on the pre-sentence report?
I have.
Any additions, deletions, or corrections?
Just one briefly. She is at McDonald's still, but she's not sure if her hours are going to be cut or not. So the $1,000 a month might not be an accurate figure at this time.
All right. Question 4. Allocution, Ms. Robinson.
Yes, Your Honor. Basically, we would ask for you to follow the recommendations of the pre-sentence investigation report. We'd also ask that you grant her HYTA status, as I believe she is eligible for that. Under everything that's in the PSI, it looks like she's doing well too. She realizes that she was young and dumb, and that's what she told her the PO when she did the PSI investigation report. And I think this is a one-time mistake kind of situation. She is doing well. She's taking care of her children. She's working. She's trying to make ends meet. Financially, it's a bit of a struggle right now for her, but otherwise, things are going good. So we would ask that you follow the recommendation of the 9 months of reporting, of Zoom reporting probation with the mental health counseling. And it's like those are the basic.
Mental health and anger management group.
Yes, and anger management group.
Okay. Any comments of Mr. Brodowitz?
People leave it to the court's discretion.
Crockett, Ms. Crockett, Angel Tatiana Nicole Crockett, is there anything you'd like to say to the court before the court passes sentence? All right. I think that was a no, ma'am. Is that correct?
Yeah.
Okay, thank you. So this has to do with count 1, a guilty plea to aggravated assault. It is the court will follow the judgment of sentence and commitment to jail. Spend 365 days in jail beginning June 6, 2023. Credit is given for 2 days previously served. Will suspend 363 days upon successful completion of probation. I'll set fines and costs at $200 fines, $200 costs. Crime victims' rights fee of $75, state minimum court fee of $50. Restitution will be determined since we have a number that is out. I will put you on probation for 9 months at the cost of $270 for a grand total of.
Your Honor, would you consider waiving the 200 fines?
Not on an ag, I won't. Yeah, not on an ag.
Would you maybe consider making like 212?
I'll keep it the same. I thought about this, and it starts from an aggravated assault, which is the highest assault of crime. So 9, it's the highest assault of crime in district court. So the 9 months probation at $30. I did notice that on the judgment of sentence, HYTA is not granted. It is a part of the pre-sentence, I believe, right?
Yes, so it is recommending to grant HYT.
So
I saw that the box wasn't checked, but it does look like they are recommending it.
All right, so I will check the box just to make sure there's no uncertainty that HYTA is granted, which is the biggest gift that if you're able to complete probation, YTA would place you in starting a completely fresh course out of this. All right, ma'am?
What you mean by that? Like, what's that mean?
That means that YTA would ensure that there's no conviction on this crime.
Okay.
All right. There may be for law enforcement purposes, but there's not for other purposes if YTA is granted and you're able to complete probation. No contact with the victim, Amaya Williams, to be with 2,000 feet. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs and or urinalysis as directed. No bars or nightclubs. To attend the anger management group. Not possess any firearms. And continue with your mental health counseling as directed by your probation officer. Ms. Crockett, do you have any questions concerning the sentence of this court?
Yes. So when the health, it's hard to do anything when I don't have a car. I'm a single mother with 2 kids and I don't have no help, whatever. So it's literally just, I'm stressed out right now.
She's just saying that she doesn't have a lot of money right now,
All
so
right.
she's a little overwhelmed.
All right.
I did tell her that she should focus on completing the coursework and classes first before paying anything else down, and then probation can obviously be completed and that can be paid off later. So as long as she's just paying what she can.
Right. So Ms. Robinson, you can pay any amount towards this debt over the course of your probation. That's 9 months. So I don't want it to freak you out in any way. It is something that's out there that you're responsible for, but it's more important right now to put priority on the mental health and counseling and your anger management group. All right, ma'am?
Okay, do I have to do that up here or down here?
No, you can do it in where you're at in Berrien County, okay?
You can go through the programming there. Just make sure that your probation agent is aware of what you're doing, all right?
Okay.
All right. All right. Ms. Crockett, you probably should contact the 54A probation department just to make contact with them, because you'll be responsible for the next 9 months to them. All right, sir? All right, ma'am?
Okay.
All right. Anything else for the record in docket 1902382, Mr. Brodowitz?
Nothing from the people, Your Honor.
All right, Ms. Robinson?
No, Your Honor, thank you.
All right, Ms. Crockett, you're all set, okay, ma'am?
Okay.
Oh, wait a minute, wait. Yeah, we got to do a restitution hearing. So CJOS for sentencing, and then we'll need a date for restitution hearing. And restitution hearing is set for July 25th at 1:30. All right, so Ms. Crockett, we have a July 25th date at 1:30 for the restitution hearing, just so we can determine what restitution will be in this case. All right, ma'am?
Okay.
All right. All right. So that's all for the record, docket 1902382. And you're all set, Ms. Crockett. Thank you for your appearance today.
Okay, thank you.
Who has Mr. Hernandez?
Me. I have his file, Your Honor. Realize this is a little bit late. I'm reading through some of the stuff for the first time. I didn't have all that's in this file. Is the court willing to meet in chambers just very briefly? About
We
that?
can, or we can reset it. I don't have a problem resetting it
Is that
either.
it? Well, I think I'm guessing that in chambers would be more helpful because I think I know everything I need to know. It's a matter of, I suppose, touching base with you about it if you're willing. And also, sorry, one other thing that's unrelated. May I approach quickly?
Yes.
This was for Mr. LaPop. I know he was heard earlier. That's a notice of a conflict issue with our office. I just have to file it with the court, so it's there.
All
You'll
right.
need to probably file the probation now instead of they have the file.
Well, I think it just has to be kept in the file because Mr. Kaltwriter is a former attorney for Mr. LaPop.
Oh,
He has
I
since
get
switched
it.
offices.
Yep.
So make sure probation has this.
Right, I'll leave that with you. We have a digital copy that I'll send on.
Okay.
Thank
all
you.
right. Just, yeah, we will. So we can talk about Mr. Hernandez. I take it Ms. Duke left.
Well, Your Honor, I mean, she's been emailing me.
Get her here.
I'm working on it.
And then we plan on running Hernandez as far as the restitution hearing. Is that correct?
I think we can go on the record with that
When
one.
Ms. Hernandez is not here and doesn't appear that she'll be.
Yeah, we can go on the record.
All right, well, let's go on the record on Ashley Hernandez.
You made me panic a little bit there for a second, Your Honor. So stuck in my-
All right, so we're on the record in docket 2300178. That is People of the State of Michigan versus Ashley Hernandez. And this was the time set for restitution hearing. There was a large restitution amount of $28,127 from Ingham County Animal Control. We've set this for restitution hearing for this time. It's 3 o'clock. It was set for 3 o'clock. It's now 3:27. Mr. Brodowitz, how did you want to proceed?
Yes, Your Honor, at this time, I would just put on the record the people are ready to proceed with the restitution hearing. However, after conversations with the defense, it appears that the defendant will not be appearing. I would leave it to the defense to put the reasons why. So I guess with that, the people would ask that restitution be ordered in this matter. And if the court is not willing to order restitution without the hearing, then a bench warrant be issued and any bond before.
All right, Mr. Austin.
Yes, thank you, Your Honor. I spoke with Ms. Hernandez, Your Honor. She did seem genuinely surprised when I called her when she realized that she had court and she had missed it. She explained to me that she had just simply forgot. She was in the process of doing some things that are required for her for probation orders, and she just forgot, and she didn't make any excuses. Ms. Hernandez is disabled. She relies on public transportation, so I think if she needed to get here today, it would take a rather considerable amount of time for her, to get here. Given that, Your Honor, I would certainly ask that the court not take any punitive actions in terms of either a warrant or any type of show cause. I would ask the court to consider adjourning the hearing for that. I know the people are here and they have a witness and they're prepared to proceed. I would also be willing to speak with Ms. Hernandez, Your Honor, and if the court would allow, I suspect Ms. Hernandez would not have any objection to me waiving her appearance and proceeding with this particular hearing without her presence. If the court is fine with that, I would just ask for a brief time to confer with Ms. Hernandez if that's a possible solution as well.
Well, this is a huge, and it's a big number, 28,000. And so my preference is to have her here, to have her here in person. So let's reset the restitution hearing with the understanding that this can't happen again. I understand not showing up one time, but if Ms. Hernandez is unable to proceed at the next time, we're stuck with some type of default, in regards to that. But it's a big number. The number for the animal control, as my understanding, is at 28,127. And I don't know if there's some middle ground here, but it is a big number. So I'm hesitant to go forward without Ms. Hernandez's presence. So we will reset the restitution hearing. You may, Mr. Austin, since you're not our usual public defender, could we find a date that's not an usual Tuesday? Would have to fit with everybody's schedule though, but it would also have to fit with your trial schedule. So let's so you can check, we might be able to do it on Thursday afternoon.
This Thursday afternoon?
Or a Thursday afternoon, as opposed to a Tuesday.
Yes, I don't know if this Thursday would work, but that might be.
No, it'd probably be out there a bit.
Sure.
We check June 22nd at 1:30.
So June 22nd at 1:30?
Is that a Thursday?
Yeah.
Yes.
So Thursday afternoon.
Yes, I believe my schedule for now is clear for that particular day, so we can do that.
All right, Mr. Brodowitz, does that work with your witness's schedule?
Yes, Your Honor.
All right. So we'll set it for June 22nd at 1:30. And Mr. Hernandez she'll be here on June 22nd at 1:30 and we'll go forward, okay? All right, anything else for the record? Docket 23-00178, Mr. Brodowitz.
Nothing from the people, Your
Mr.
Honor.
Austin?
Nothing further on behalf of Ms. Hernandez, Your Honor, and I do appreciate the court
All right,
accommodating us on that.
All right, thank you. And that's all for the record in that file. And then Mr. Brodowitz and Ms. Sutter, we can talk about the other file here.
Thank you.
Okay.
All right,